Dope boys with them knives.
The game so cold, but I'm so hot. Same old shit, still on the block. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. The game so cold, but I'm so hot. Same old shit, still on the block. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. I'm dope boy fresh with dope boy not. Down 8 gram, headed straight to the block. Pirates this water while till it's hot. Mix it double up, turn a little to a lot. Right hand on the cell phone, take an order. Left hand 360 motor to a lot. Blue holler tip, got switches on the dot. State game, true sippers can't be stopped. Laughing at you haters while I'm thumbing through the paper. Says long live to the bottom, won't you meet me at the top? The nigga ain't shit, yeah, get that a lot. Won't be deterred and I won't be stopped. Shaq Diesel number one, I post up on the block. 24/7 cause the hustle don't stop. 31 flavor, take an order like a waiter. I be selling more gas than a local truck stop. 1200 strong, 4 pounds of the zop. Got me shining, I'm a star. Ask about me, I am legend. They gon' tell you who we are. Fuck these niggas, fuck these bitches. Get money, all I know. No love for these bitches. Never saving these hoes. The game so cold, but I'm so hot. Same old shit, still on the block. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. The game so cold, but I'm so hot. Same old shit, still on the block. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not.
When I'm thinking about the past, yeah, gon' get some knots, gang, we at the spot. If we ever was short, then it's back to the block, you probably get shot. Every day the sudden change, we getting money, that's one thing that's never gon' stop. Real dope boys do what it takes, playing high stakes, living to die. Do your time, keep it quiet, no matter who you are, don't get what you got. Stack it up, that's the bond to stay fresh. Oh, they think that you're not. Take a roll with a hoe, they gon' let you go. Somebody's gonna say you ain't hot. Just invest in yourself, don't worry about nobody else. There ain't no handout. If you say the same, put it on the chain. Let them see you ain't tied down. Got a couple rings, did a lot of things. I ain't really gon' talk about it. Give me a trade, get you bitch to go. She gon' show up and show out. So don't ask me what a dope at, cause you already around.
The game so cold, but I'm so hot. Same old shit, still on the block. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. The game so cold, but I'm so hot. Same old shit, still on the block. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Dope boy fresh with dope boy not. Same young nigga came up in the trap. I'm dope boy fresh with dope boy not. Never been a hoe, I stay on go, so what the business? Nigga talking reckless, shoot this bitch ass with the quickness. Now he bleeding, sorry, begging, asking for forgiveness. Bow, 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 limp biscuit. All my niggas wildin', they done labeled us a misfit. Wake up every morning, 2 or 3, 5 in the tidbit. Oh shit, didn't nobody come to see you old, it's some focus. Shoot 100 shots, no reloaded. Master of the game, you would think I'm into coded. Memphis niggas spit this pimpin', mackin' like I'm golden. Ho, with my money, you gon' turn me to the old me. Say hi, first class flight, I'm in the nosebleed. Copy, cooking, whipping, shipping, till you count the proceeds. OG, I've been moving pack niggas since 03. Low key, niggas hating, but they don't want no beef. State gang, true sippers, bitch, I bet we gon' eat. Get jammed, get a lawyer, make it bunny, don't speak. Pour up, oh, I need some more. A nigga had a long week. Shout out to my plug, he showed me love, he out in Long Beach. I'm true geek, walking by myself but left with 2 freaks. Ooh, we nothing in they mouth and on they booty. Austin Power swag, yeah baby, this is groovy. You can call me money boy or you can call me nudie. Hood niggas, churches, chicken, let me get a 2-piece. Top down, 2-seater, let me feel the 2 breathe. Gotta hold it steady, chopper, kick it back like Bruce Lee. Lately I I've been in the zone, I guess I'm in my 2-3. Don't call my phone for nothing less than a QP. Feeling like the Migos, cause my bitch is bad and bougie. All my haters love me, all these bitches is some groupies. Came a long way, I like to introduce the new me. Standing on business like I'm king or like I'm Drewski. Call me Run Island cause I like my love for choosy. When we link it's a movie, she bustin' like a Uzi. I love the way she do me, I beat it up like Uzi. She dancing just like Suki. Call me Run Island cause I love my love for choosy. When we link it's a movie, she bustin' like a Uzi. I love the way she do me, I beat it up like Uzi. She dancing just like Suki. I never been a hoe, I stay on go, so what the business? Niggas talking reckless, shoot his bitch ass with the quickness. Name pleading sorry, baby, asking for forgiveness. Bow, 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 Limp Biscuit. Never been a hoe, I stay on go, so what the business? Nigga talking reckless, shoot his bitch ass with the quickness. Name pleading sorry, baby, asking for forgiveness. Bow, 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 Limp Biscuit.
Good morning, good morning, good morning. Well, damn. How y'all doing? We're about to get back started on the YSL Mounk Tounk testimony and cross-examination. Oh, come correct. I figured out why they were saying that he said his plea deal was false, because he said there was stuff in there that he didn't agree with and all of that.
We're sharing through a different screen, and we're going to go ahead and pick up on these charges at 6:40 where we stopped. It has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3 special conditions of sentence of this plea agreement. The state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case.
That's right. They still reading this damn
Schedule 1, 2, or
his
3
plea
drugs.
agreement. This is crazy.
Defendant shall within 30 days
Shall be
present
long
positive
as
tests,
hell.
undergo drug rehabilitation as designated by the court or the Department of Community Supervision, and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed a drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceedings. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word B-E-G-I-N to B-E-I-N-G. And Mr. Sledge, is that your initial above the strike through of the word begin to change it to being?
Yes, ma'am.
Okay. And may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgments?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yes, ma'am. And
is that the statement to which you sign your name underneath?
Yes, ma'am.
Your Honor, the state tenders as evidence State's Exhibit 1AS. Mr. Sledge, I'm showing you, and Your Honor, I'll show defense before I present it to him, what was admitted during that session as 1AS. If anyone wants to see it, if not, I'll go ahead and approach the witness. Mr. Sledge, would you please take a look at 1AS and tell me if 1AS, which was admitted for the purposes of your plea, and the document we have been referring to, yes, thank you, as states 444 Yankee, and I will now add back the first two sheets. Would you please look at those two documents and tell me if states 444 Yankee is an exact copy of State's Exhibit 1AS that you signed on December 28, 2022?
Look at the whole thing, Justin.
Yes, sir. Please look at the entire thing.
Yes, I remember though.
And is State's Exhibit 444 Yankee an exact duplicate of the document labeled State's Exhibit 1AS?
Yes.
Right. Thank you, Your Honor. One moment. That's all the state has.
All right, is there a cross-examination of Mr. Sledge? All right, go ahead, Mr. Sharp. Yes.
Mr. Kokomo's in need of the Zoom link.
It's the same it's been all week. Can you look at maybe a prior day's email? Or the state will forward it. Thank you. He's got it. He's in.
Mr. Sledge, good morning.
Good morning.
My name is Max Sharp. I represent Shannon Stillwell, okay?
Yes.
All right. I'm going to be asking you some questions about that document that you were just reviewing. Do you have that up there with you?
No, she took it.
Okay. If I ask you specific questions about that document, do you think it might be helpful for you to have it in front of you to refresh your recollection?
Yes.
Okay. Your Honor, ma'am.
Yeah, I think it's right after the court order.
Okay.
Okay.
I'm not.
Okay.
We'll get there.
Okay.
And just please listen to my questions and then answer truthfully, okay?
Yes.
Ms. Sledge, I'm going to ask you to go back to December 28th of 2022, okay?
Yes.
Now, that is the day that you pled guilty, correct?
Yes.
And that's also the day, as I understand it, that you initialed that document. Is that correct?
Yes.
Initialed the factual acknowledgements within the document, correct?
Yes.
All right. Let me ask you one question.
Cross-examination
What
has
day
begun.
were you arrested on this case?
I want to say May 27, 2022.
27th. Limited math here. Okay. So May 27th of 2022 to December 28th of 2022. That seems to me 7 months. Is that correct?
Yes, 7 or 8.
Okay. So on December 28th of 2022, when you initialed those documents, you had been locked up for 7 months.
Yes.
Okay. You had previously moved for a bond in this case, correct?
Yes.
You moved for a bond on October 13th, I believe, 2022?
I don't remember the date, but yes, I know.
It was in October?
Yes.
And the state opposed your release on bond, correct?
Yes.
And Judge Glanville denied bond, correct?
Yes.
Okay. So on December 28th, 2022, you had been locked up for 7 months and 1 day, and you did not have a bond.
Sustained.
On December 28th, 2022, you did not have a bond, correct?
Sustained.
Let me ask you, when you were locked up, we're saying locked up, where were you living? Where were you held?
At the Fulton County High Street.
Okay, that's Fulton County Jail?
Yeah, jail.
Okay, we're not, generally speaking, is that a nice place to be?
Everrule.
No.
Is that a dangerous place?
Yes.
Is that a filthy place?
Yes.
Okay. On December 28th, 2022, there were you've already shared with us that your mother was ill.
Yes.
Certainly, on that date, you wanted to get home to your ill mother. Isn't that correct?
Yes.
You are also a father, right, Mr. Sledge?
Yes.
You have 8 children, is that correct?
Yes.
On December 28th, 2022, I don't need to know the age of every child, but what was the age ranges?
23, the youngest 9.
The youngest was 9.
He's 9 now.
Okay, so about 7.
Yeah, about 7.
And do your children live in Atlanta?
Yes, all of them.
Okay, do you spend time with your children?
Yes.
Sustained.
Do you attend to your children's daily needs?
Sustained.
Your Honor, might be heard.
Okay.
It goes to his need to get out of jail.
All right, we'll get to it.
Okay, do you attend to your children's daily needs?
Yes.
Do you drive your children to school?
Let's move along a little bit.
Okay.
I know, right?
Did you have a significant other at the time?
Yes.
Everrule.
Yes.
And I don't even need to say her name, her initials are DB.
Yes.
On December 28th, 2022, did you miss DB?
Yes.
Did you miss your children?
Yes.
You indicated that Derek Wright is your attorney,
Yes.
and he's represented you in the past,
Yes.
and you hired him on this case.
Yes.
When you testified, I want to make sure I'm correct on this, you paid him a certain amount of money, and I don't need to know the amount. He's testified that he did not, his understanding was he did not pay his attorney. The money that you paid your attorney, you knew it wasn't enough for him to go to trial on this long case, correct?
Yes.
That was your understanding.
Yes.
That was his understanding.
Yes.
You did not have a an attorney to take this case to
All
trial.
right, no, now we all know that that's not true. That anybody who can't afford an attorney is entitled to get an
Well,
attorney
I'm gonna
without
get
cost to them.
I'm gonna get there. There were people in this case that couldn't afford an attorney, correct? People were.
They ain't object to the shit you was
Don't talk
doing.
over each other. That's
Miss
not
Love being
relevant to the
rude.
question that you're asking him, nor to this trial going on right now.
Your Honor, may I be heard?
Yes,
You let them be heard.
If he knows he's going to
you
sit,
may, yes. You know what? Let's break for lunch, because I know that this is gonna take more than 30 minutes for you to do your cross, so let's just break for lunch right now.
Damn it, man.
Huh? Time? Oh, right, well, I've got some, we have to deal with some other matters, let's say 1:30.
All right.
Exhibits that may be used during the cross.
Yes, Your Honor.
All right,
Oh, they arguing
Try to
instead of
be-
going to lunch.
respectful and treat this with integrity. This is a guideline. Okay. This is very serious.
I miss some.
My intention to offend anyone.
Oh, okay, this was
Every
what she
day.
got on Miss Sylvia.
And I will never use the names anymore if it offend anybody, because I know, reach out. Very serious.
Somebody snitched.
I definitely.
I
Okay.
wonder who snitched on Miss Sylvia.
All right, I don't know if y'all have had an opportunity now, we can get back to our, issues with, or potential issues with some of the exhibits that may be used during the class.
Yes, Your Honor. All right, the court's permission, may I maintain my seat because I'm looking at.
You may.
So, in the Dropbox that we received from Defendant Williams, included are what appear to be, and I'll just take them in turn, exhibit number 15 alpha for Defendant Williams appears to be a video of LeBron James
It was Anthony Davis.
dabbing up someone and wiping his nose and saying slime.
Okay.
We object to that.
Why?
Relevance grounds.
I
Everybody
suspect the
do it.
relevance is gonna, well, I don't want to speak for you, Mr. Steele. What's the relevance?
Everybody
It just
does.
shows that this is not unique to YSL
Okay, well, I
or
mean,
in a gang. Also, Your Honor, it's already in evidence.
it's already in evidence anyway.
Yeah, it's already been admitted, but she want to object to something
Yes, it's
that's
already-
already
that's probably
admitted.
right.
That may have been the case. and if that's
If
the
it's
case,
not, I
then
can see, I'm not gonna overrule the relevance.
Okay.
To the extent it's not evidence. All right, any other?
And
What's
yes,
Sylvia
there
say?
are apparently, so I'll name them again, 16 alpha from Defendant Williams is a person unknown to the state, a random person in what appears to be a TikTok video. And this person they're singing,
Okay,
apparently they're singing Defendant Williams' song.
okay.
And they're saying, and he's saying slash, 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 they're lip syncing to it. It's a young female wearing a skull cap, lip syncing to Defendant Williams' song.
Which number is this?
Okay, in the beginning, there's no skull cap. She
Oh,
just got
okay.
her hair straight
That's fine.
down. And then
She
later on,
mad about
there's
the
a young
TikTok
lady in the
video.
Okay,
Again, he just showing how
We object on 2 grounds, relevance.
what Sled said. Mounk said, man, he ain't seen white girls, little boys. It was a thing. It was a TikTok trend. It was trendy. LeBron did it. Anthony Davis and them was throwing up slime and shit. It just, dang YSL. You gotta stop it, Miss Love. You reaching. You reaching, Miss Love. You
And-
reaching.
In as much as it is Defendant Williams' statements, his statements, we would object as self-quotations.
I don't understand
you
this.
know,
So
there is no objection
or-
that is, evidentiary objection that is
Let me-
self-quotation.
Self-serving hearsay. It's hearsay, Your Honor, and there's no exception for it, so I'll leave it at that.
it's non-hearsay. I'm not using for the truth. I'm just showing what exactly, Mr. Sledge said, that slime is just used, slat is just used. He says it's used by people all over the world. He said people can say YSL, they're YSL. There's no initiation. I don't know, though, Your Honor, if
All right.
I've seen these before. So
The what? You don't know what?
I don't know if I can lay a foundation. I don't know if I've seen these before. So
So, I mean, if this is in, exhibit that's showing somebody lip syncing to one of your clients' videos where he uses whatever this terminology is, that doesn't establish anything other than he put these things in a song and people sing songs. That doesn't establish that she or anybody else would have used that terminology otherwise. So I'm going to exclude that. That does not show what you allege it to show.
I think that goes to potentially weight, but I understand the court's ruling.
Additionally, Your Honor, 16 Bravo from defendant Williams is a.
Sylvia better take that fame and run with it. It is what it is. It's not the worst thing in the world. Everybody in the courtroom done been admonished. Kayla done been admonished. Woody, shit, the witnesses, the Miss Love, the defendants, everybody done had their term. So it is what it is. Just enjoy the increase in the algorithm. I sure put the video up, but I ain't gonna commentary. I hadn't seen it, so I can't tell if it's. Like I said personally, I don't think it was anything for the judge to address. Now, had she had been giving out what the judge said, personal and identifiable information, and describing what the fuck they was wearing and their haircuts and shit, then I could see her saying it. But just because they call somebody SpongeBob and shit, she interpreted it as it being disrespectful, and she didn't mean it that way. That's the thing about interpretation. But Miss Sylvia will be all right. She gonna weather the storm.
Video that I think it's safe to say has not been tendered previously. And it is, as it's loading, it's a young man whom we don't know the identity of, who is, I think, either singing or lip syncing. He's lip syncing the fitness song.
All right, let me say that anybody who is just some random person lip syncing or singing a song that Mr.
You gotta allow it, Judge.
Does not establish anything other than once he puts out these songs, people like the lyrics and sing the lyrics and.
No, Judge, that ain't fair. That shows that it's other people saying slime. Old people are wiping their nose. Why they wiping their nose then? If the song is catchy, why they wiping their nose? Why they calling each other slime? They saying slat. And they claiming YSL, which is what Mounk said. Everybody was claiming YSL. You ain't had to do nothing to be YSL. You just said you was YSL. That don't mean you was gonna be recognized by the record label members or whatever the fuck, but you can still claim it.
That doesn't establish anything other than
that
it is now in common parlance in the music business is probably not even an issue.
So I think that is the case for 16 Alpha, 16 Beta, 16 Charlie, 16 Delta, 17 Alpha, 17 Beta, 17 Charlie, 17 Delta.
No, that's wrong. So it would be under 16 A through F would be consistent with this honorable court's ruling. I will not attempt to introduce it. 17 A through E, some of them have already been admitted. Other ones are similar. It's just people who are using the nose wipe, if you know what I'm talking about, the finger across the nose. Okay. That's what those are.
And those are already in or no?
No, not all of them.
No. And do we know when these came into existence?
Yes. Mr. Trentavious Stevens and Jeffrey Williams exhibit, or JW exhibit number 17A is already in evidence, and it's already marked 7 through E.
Of 17
Sure. And I guess at some point we really do need to sit down and sort out the evidence that came before me, but yes.
All right, so we do not have that same memory, and to the extent that it is not, if it is not, we would object on relevance grounds. It is an unknown person. All
right, do you know when it came into existence, roughly?
We have the exact date. It's also 15, I think I said 17.
15A. 15A is LeBron James, right?
Already in, and Mr. Kumo is getting the date, if that's okay.
So you already talked about 15. If it's
15A is not LeBron James lip syncing, is it?
It's LeBron
January
James.
22nd, 2024 was admitted to
Yes,
January 22.
Is he also lip syncing one of Mr. Williams' songs?
Mr. LeBron James is coming into a locker room. He has teammates. He's a basketball player.
Yeah.
I know you know that.
I know, you're setting up for the record. He's one of the most famous people in the world. Yes.
Is greeting his teammates.
Okay.
And as he's greeting, he's doing different type of greetings. And one of them is the wiping of the nose.
Okay.
That's what it is.
Okay.
Other people in there, and I have to look to get the exact numbers, but is a baseball player on the Padres. Last name is Musgrove, Musgrove. He throws a pitch on the diamond. He strikes out the batter. It's the New York Mets, and he wipes his nose. Another one is Stephon Diggs. He's a football player on the Buffalo Bills. At that time, he's now on the Texans in Texas. And their quarterback, whose name I can't remember, Josh Allen, they both greet. It's the same type of thing. They greet in the huddle, and Josh Allen's going around other people. They wipe the nose.
And these are all in 15A?
No.
They should be 17A, then 17B, then 17C. I separate them all.
Okay.
So, Your Honor, we'd like to,
17D and 17E. And they just go consecutive. And the next one is C.D. Lamb. He's a football player on the Dallas Cowboys.
He going down the list. So y'all can't say it's just YSL. Them folk I never met you.
20, maybe a little earlier, but yes.
Judge, so our objection is that, one, as we look at
playing
starting
your
at
game against you, Miss
17A, these videos that Mr. Steele or Defendant Williams is seeking to have admitted are nothing more than people imitating a hand motion or lip syncing words that Defendant Williams appears to have made popular.
But you asked them what wiping the nose meant, and they were like nothing. And they showing a whole bunch of other people that's wiping their nose, and apparently it means nothing to them because they ain't out here killing and racketeering and organizing. These niggas play sports. They shoot balls and stuff. Pause.
Through his music and his songs. Defendant Williams has SLAT tattooed on his index finger as he wipes his nose and is photographed in pictures and publications with that index finger, nose wipe, and word SLAT. The fact that his music that he has circulated that people have taken to it and emulated it has absolutely no bearing whatsoever on whether or not either defendant in this case, and specifically Defendant Williams, committed any crime alleged in this indictment. It has no relevance whatsoever. It is a circular argument to bring about something that someone else is doing now because Defendant Williams did it. I don't believe anyone, and I can't speak for everybody who's going to get up there, but I don't believe that anyone is going to be able to say, unless they bring in the people who actually put these videos up, when these videos were created, when they were done. There's no foundation, I think, that can be laid, and I don't think that any of them are relevant.
None of the shit you played was relevant, but we sat through it.
The reason I asked about when they came into being
It's already in evidence. The fuck you objecting about something that's already admitted.
Of the fame and magnitude of Mr. Williams has brought into more common parlance, if you will, within society. It doesn't really establish anything more than that. Why don't you pick 2 or 3 and let's just go with that.
Why you can't play all of them, Judge Page, Miss Page. If you gonna allow 2 or 3, why not allow all 8? What's 5 more? Come on now. Come on, G. Hell, in some of these instances, these people doing the shit made it more popular because they the ones with the real drawing power. Young Thug is popular, but he's not as popular as any of those people you named, including the baseball player. That nigga's still known. And I don't know him personally, but I'm sure wherever the fuck he play baseball at, he is recognized every time he walks out in the city. He has a bigger platform than Young Thug. That TikToker probably has a bigger platform than Young Thug. They got the influence too. Come on, Paige. It's already in evidence. How are they gonna object to something that was already admitted under the previous judge? That's unfair. You shouldn't be able to touch that at all if it's already been allowed by another judge. You had an order. Call the roll.
Is just something that doesn't mean gangs at all. It just means, you know, this is what's cool in common culture right now. They'll let you do that. That will not prevent the state from arguing maybe what it is now, but that's not what it originated as. It's not what it means to the people in YSL. Y'all can argue that in front of the jury. But we certainly don't need, you know, 15 or 20 of these. So pick like 3, okay?
Also, all right. That 222 Alpha XX from Defendant Williams
Would
is
be
a compilation that
the nigga done told y'all a million times he bullshit on.
These are flyers
He said he don't care
Defendant
about
Williams
nothing.
that we object to.
Okay.
Based on
He
relevance.
said he act like he
They
care,
are
but he be playing.
Self-serving. They are
He's a sociopath.
hearsay. So we object to 222 Alpha through XX. We have not yet looked at all of them because we didn't realize it has so many exhibits contained in the one. So I'm still sorting through them. They appear to be Defendant Williams flyers.
All right. And what would be the relevance of those?
So this, I couldn't get these. The state gave it to us in discovery. This is from Mr. Williams' Twitter account. And he advertises.
No, this is 220.
This is 220 Alpha through XX?
Yes.
Okay.
So he advertises his shows.
Yeah.
And what I did was listening to Mr. Sledge, he may know about these shows.
Okay,
So-
in which case?
So then the state is saying that Mr. Williams is on Cleveland Avenue and Mr. Williams' notoriety has to be increased because of a drive-by shooting. And I'm saying the opposite. Mr. Williams is extremely busy. He's always in a studio. There's been testimony like that. There'll be more. And he's constantly performing around the time of 2014 going to 15, which is the relevant time period for Mr. Sledge's testimony.
And is that what all of these are from?
Yes. So that's why I put it together. Now, it is extremely relevant because what the state is trying to show,
And the
that
state
Mr.
gave
Williams
it
somehow
in
is so
discovery.
interested in this gang that is on Cleveland Avenue and selling drugs from a convenience store. And I want to show the truth of what he's actually doing and how busy he is. So that's why these are here. They're not anything to do with hearsay. And this gentleman may not have personal knowledge of these events and shows because he was going with Mr. Williams as he testified to. And that's what I was going to do.
Are you going to hand them to him
Yes.
as like an exhibit that's a composite of a bunch of flyers?
I already did. I gave it, well, I didn't hand it to him. I gave it to the Honorable Mr. Wright, who I assume, because I know Mr. Wright has gone through it with his client. And then I have a hard copy and I have the thumb drive, by the way.
And they go from, it looks like they start in September 2014 and go through June of 2015. All right. You don't intend to display each one of these separately, do you? Because that's.
I would try to get them into evidence and then use them.
Ma'am, you don't be see, Judge.
That's right.
Judge, you not being fair. You don't ask the prosecution this shit when they do all the bullshit they doing. And this and Weinstein done asked you several times to put a clock on these folks. Now you want to speed the defense up, but you ain't got no time limits on the state presenting their case. This bullshit. You're not being fair. Mistrial. Recusal.
57 of them, or however many there are, okay?
Well, I was going.
I know, I mean, the jury will have a whatever, inch thick
Yes.
composite exhibit to look at.
But I will only, yes, I'm not going to go through
In
every one.
terms of court time, okay.
I will be,
All right, I'm gonna overrule that.
So, Your Honor, the response that Mr. Steele gave regarding it showing that Mr. Williams has a show or he's busy at shows and can't be on the corner selling drugs. One, these are flyers that he created. These are not photographs of Mr. Williams at the show. It doesn't even say that he went to the show.
He should, okay, well, I mean, then I guess maybe you can make that argument, but he's got all of these things lined up on his schedule.
And then as to Defendant Williams' exhibit, and of course that would be, I guess this of course is subject to a proper foundation being laid, assuming he can even talk about these, but exhibit 255 Bravo, Your Honor, all right, is a.
So we're going to a different exhibit now?
Yes.
Okay.
It is. And would the court give us a number, like, I know the court said a smattering, but is there a number, all of these flyers?
Yeah, if you feel like this is what's reasonable, that it's getting to be a waste of time, then you can make that objection.
Yeah.
Okay, let's look at 255. What's our issue with that?
So, Your Honor, 255,
Thank you
Bravo
for the
appears to
$5
be
cash app.
a collection
Thank you, Sister
of
Avanti,
tweets.
$10 coming on the Cash App. Thank you, sister. Next time, make it 20, but thank you for that 10. I know you barely had that. Thank you, sister.
Their sister, baby, mama, and granny get on the stand and tell the guy's honest truth. I just don't get it. These appear to be tweets from 2023,
Yeah,
which are after Defendant Williams put his,
they look to me like they're from 2013.
I'm looking, I don't see, okay, so. Okay, so as my team is telling me, as we look through them, some.
Oh, it's way more than one page. Okay.
So 2013 to 2024.
All right, we don't need the ones past when Mr. Sledge himself used the term.
And so, Your Honor, we have never
And how
disputed that anybody else said that Mr. Sledge, in his testimony, he said it's a saying that people say. I didn't argue with that because he said a lot of people say you lie to your mom, you lie to your sister. My question was, do they say you need to get killed?
Yeah.
So this is irrelevant.
That's just a saying. That doesn't mean it's just a saying. Y'all gonna hold him to a saying? He didn't say I was gonna kill you. He said you need to be killed. Some people feel like the people who have abortions should be killed. That doesn't mean they actually out there killing women that had abortions. It's just a figure of speech.
And showing that somebody else says you lie to your mom, you lie to your sister.
Okay, no, it goes beyond that though, because all of these also include, but tell the God on.
Yeah, and tell the God's honest truth, right?
So that, yes, you can use some of those to show that because you did ask him about all of that part. And it will be clear that none of these say, but then you need to be killed. So, all right.
So
we don't need
all of
anything
them,
past that then.
is he going to be putting in 12 pages of this?
I don't know how many pages there are
It don't
there before
matter.
2015, but I think you can probably establish that point with a couple of pages for us. All right.
Why do you keep limiting them, but you're not limiting them?
And the point that state believes you want to make that objection then.
When I say a couple of pages, I mean one or two or two or three. Because they're like 7 or 8 on each page, so that'll make the point.
And that's all prior to
I
2015.
just expect, because I know we haven't defined a smattering, but I've defined a couple now. So I expect Mr. Steele to abide by that. And then what else? Yes, all before whenever he used it. When did he use it?
2015.
Okay. So
January
yes.
2015.
Mr. Steele has, when did he use it?
July 2015, Mr. Sledge.
That's what Mr. Sledge used.
Yeah, that's what I'm asking. So what you use to demonstrate that it's in common parlance needs to all be before that. What else?
255 Bravo is this, wait,
That's what we just were looking at, I think.
so 255 Alpha is the same.
Okay, that's the one with all of the flyers for, yeah, we've done that one.
So no, 255 Alpha literally is another 32 pages of tweets.
255, okay, I'm sorry.
Is a PDF, a 32-page PDF
Why you
We don't
mad?
need that, right?
of
We had to look at all them damn pictures on
Mr.
Woody
Steele.
and Mr.
We don't need
Sledge shit.
255 Alpha and Bravo, right?
Yes, we do.
Okay,
a couple of pages through there.
with 2 or 3 pages showing that. Okay. All right, what's next?
I don't like how she trying to rush the
It's
defense. She limited.
ruling in effect with
what they
respect
can
to,
do,
and I
but
think the
not
court
the
says matter.
prosecution.
I don't remember which one that
Same
applied to,
way.
with the wiping of the nose.
The smattering was the flyers showing the shows.
Okay, so
He's gonna pick 2 or 3 from his exhibit A, I don't, or wherever they are, 15, whomever it is. I don't know whether you want to use famous people or non-famous
smattering.
people, but
She's so country. You got
really about singing the songs. Those are just out. But people using the same kind of hand gestures, pick 3. I don't care what they are. Okay, so what else?
So Mr. Williams, for instance, on exhibit 34, if it's not already in, it's Defendant Williams himself sitting there wiping his nose. And I think that might already be in. So I'm not sure if that's one that is being offered now. But for the ones that are not already in evidence, is the court's ruling that 2 or 3 other people that are not him who are wiping their nose are what will be allowed?
Wiping their nose, or if it's some other hand sign, just 2 or 3 things, 2 or 3 of these to demonstrate, oh, other people in the world do this too.
And Your Honor,
I don't know that it's going to establish anything, because this is 10 years after we have heard that YSL, which might be or might not be a gang, was created. But
so Your Honor, and we would ask as well, because I've seen, I'm not saying anyone in particular, but we would ask that reference to what is contained in the picture. For instance, do you recognize LeBron James wiping his nose? Not be made until it is established whether the witness on the stand, who is supposed to be the witness for whom it is entered, can establish whether they've seen it, known, no.
And now you want to limit how they ask their questions before they even asked? What the fuck?
do you recognize LeBron James wiping his nose? Are you familiar with this? Have you seen this before in your life?
And given that Mr. Steele has already given Mr. Wright the exhibits, the answer will be, yeah, I've seen it.
Well, the fact that I think Mr. Steele probably knows how to handle a witness well enough to lay the foundation properly.
I'm just asking based on
If
what
you
has
want to
happened
then
so
get
far.
up and ask, never mind, I'm not even going to suggest that. Okay, so are we clear on that? He can ask before today. What else?
I think that the videos of people lip syncing, the wiping of the nose, and the tweets about lying to your mom and telling the truth in court are the only 3 categories.
Okay.
And so since there are so many, I think we've covered
All right.
that. We'll look at it
All right,
closer.
and then we've got the proposed exhibit for Mr. Huey. Is there any issue with that? I haven't looked at that yet, but.
So we don't object to the whole thing coming in, but I believe Mr. Matthews has indicated he wants to take the writing off. But if
I don't know what the writing says. And who are these people in this exhibit? Okay. Yes, and
1 second.
I was talking to your mic. Okay, well, all right.
and to be
Hang on,
fair,
let's let them finish whatever, and then get back on the same page all at the same time.
Skipping, y'all. I'm skipping. I'm skipping.
No, give
Okay.
us a half an hour and we'll be back at 1:15, okay? So that we don't
They unmuted the mics to say that.
Okay.
proceedings.
Okay. Which
That
now,
says what?
Mr. Sykes,
You still got 4.5 hours of this damn trap. I wonder how many more breaks they gonna take when you spend that much spend. At least 2. I say they at least gonna take 215s.
Which we're talking about?
Your Honor, I was under the impression that this plea agreement, Mr. Sledge's plea agreement, had been admitted in evidence. But I think I was just basing on the fact that it had an exhibit sticker. Which
That says what? A1A? No. It's neither that or 444Y is in evidence. That has an exhibit sticker because that's the exhibit sticker from previously, the actual plea proceedings.
Okay. All right.
And it has the AS because it was for Antonio.
Right, it hadn't been tendered, neither of those, neither it nor the 444Y has been tendered for admission here. Was it 444Y?
444Y, right?
That's what
Not
she was
tendered.
using before, and she had him compare the two. Right. But it's not in either.
Okay.
It's a copy.
What is the video?
The video is 442Y,
Thank you.
and that's the one that's just the portions.
Right, and that's been admitted.
Yes. We're ready.
I'm catching up.
It's a lot of numbers.
Thank you. You're talking about the numbers, John?
We'll figure it out.
Thank you.
All right, go ahead, Mr. Sharp.
Thank you, Your Honor. May it please the court. Good afternoon, Mr. Sledge.
Good afternoon, Mr. Shaw.
We had just, last thing I asked you was about your representation. Do you recall?
Yes.
Okay, and that you had not hired Ms. Wright for trial.
No.
On December 28th, 2022, okay, you were aware that, well, let me back up. Typically, have you ever had appointed counsel?
Objection, relevant.
Just trying to educate on how it usually works. I'll move on.
Okay.
On December 28th, 2022, you were aware of co-defendants on this case who had been arrested.
Yes.
And there were some of those individuals who could not afford attorneys, correct?
Right.
And you were aware that some of those individuals were in Rice Street,
Yes.
or they were in Rice Street,
Yes.
and those individuals that could not afford attorneys had not been appointed attorneys as of December 28, 2022, correct?
Yes.
And isn't it true that you did not want to be in their position?
Yes.
Meaning you did not want to be in Rice Street without an attorney?
Yes.
Okay. You believed, for the purposes of having representation, it was in your best interest to resolve your case via plea on December 28, 2022.
Yes.
Do you know what coercion means?
No.
Okay. What about pressure?
Yes, I know what pressure means.
Okay. Being in, and this is your truth, I'm not asking for a legal definition, okay?
Yes.
Okay. Being in Rice Street for 7 months prior to your plea, did that put pressure on you to accept this deal?
Yes, a lot.
Okay. Being separated from your sick mother and your children. Your Honor, he testified for 3 days already. I've been going for 10 minutes.
Yeah, but you did already ask him that.
Well, I'm just trying to conclude this line of questioning, then I'll move on.
Okay.
I haven't asked him about pressure yet. He wanted to go home, and now I'm asking about pressure. Being separated from your sick mother and your children, did that create pressure to plead guilty on December 28, 2015?
Yes.
Excuse me, December 28, 2022.
Yes.
And the fact that you did not have a lawyer for trial, did that create pressure on you?
Yes. That,
As an answer, relative non.
how about facts not in evidence too?
That's not.
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty?
That's the fact on that. And it also calls for.
Overruled.
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty on December 28, 2022?
Yes.
All right, I want to talk to you about the plea offer. And when you need to, you can refer to it, but I want you to listen to my questions, and if you can answer without, that's fine.
Yes.
Okay. At some point in late December 2022, you became aware that the state was making a plea offer in your case.
Yes.
Okay. And the state's plea offer was an offer for probation.
Yes.
Okay. And probation, I know we know what it is, but for the jury, probation is you don't have to be in custody, right? You're released.
Yes.
Okay. And you have to check in with a probation officer.
Yes.
In your mind, that's preferable to prison.
Yes.
That's preferable to sitting in Wright Street Jail, correct?
Yes.
Okay. Probation would get you back to your family.
Yes.
Get you back to your ill mother.
Yes.
And that would solve your issues as far as hiring an attorney to try the case.
Yes.
You were interested in a plea for probation.
Yes.
Okay. Now, as it turned out, there were factual acknowledgments that you would have to initial to receive that offer of probation, correct?
Yes.
Okay, when you first learned about probation, did you realize that there would be factual acknowledgments that you had to initial?
No.
Okay, but at some point your attorney told you to get this probation, you're going to have to agree to factual acknowledgments.
Yes.
Let's talk about the factual acknowledgments. Do you remember the first time you saw the factual acknowledgments on that plea form? Was it December 28th?
Yes, I want to say yes.
Okay. Could it have been earlier? To the best of your recollection.
Yes, I think if I'm not mistaken, yes.
Okay. Did you ever write a statement with your truth about what happened in 2015 and give it to Ms. Love or any other prosecutor in this case?
As to your truth and what happened in 2015, they overall.
Did you say 2015?
I did. About what this case is about. Did you ever write a statement?
Oh, about, not in 2015.
No, about 2015.
Overruled.
No.
Okay. Did you ever sit down with Miss Love before this plea?
No.
Okay. Did you write the factual acknowledgments?
No.
Okay. On that sheet of paper in front of you, I believe it has, do you know what letterhead is?
I think it's the stamp, something like that.
Okay, on the top of the paper.
Yes.
Is there a letterhead that indicates whose office that paper is from?
It's a family will. That was talking about, right?
Yes.
Yes.
Okay, from the Fulton County District Attorney's Office?
Yes.
Okay. Do you know who wrote the factual acknowledgments?
No.
Okay. Who presented the factual acknowledgments to you? Was it Miss Love?
Yes.
Okay. Did you know Miss Love back in 2015?
No.
Was she hanging out with you in 2015?
No.
Okay. I'm not trying to embarrass you. You're a smart man, okay?
Right.
But you did indicate that you didn't know what the word notoriety means.
Yes.
And you've also just said you didn't know what the word coercion means.
Yes.
Okay. Could you look on that in that document with the factual acknowledgements should be page 3. I'm going to ask you to look at factual acknowledgement 1. On the last line, does it have the word notoriety?
Yes.
Okay. I'm going to look at factual acknowledgement 5. On the last line, does it say notoriety?
It's on 5.
Yes.
Yes.
I'm going to ask you to look at number 16. On the 3rd line down, on 16, does that say notoriety?
Give me 1 second. It's on what line?
The 3rd one down on number 16. That's page 5.
Yeah, I'm on page 5.
Okay.
Yes.
All right. Could you go to page 6 and look at the last word on page 6? Does it say coercion?
Yes.
And those are words to this day, I guess before this trial maybe, that you never knew the meaning of.
Still don't know the meaning of.
Okay. Do you write sentences using words that you don't know the meaning of?
Objection, Your Honor. Relevance.
Sustained.
Now, in preparation of your plea, whether it was on December 28th or before that, you did speak to your attorney, Mr. Wright,
Yes.
about the acknowledgements, correct?
Yes.
And you brought certain acknowledgements that are on that sheet to the attention of Mr. Wright and told him you don't agree with those.
Yes.
Okay. And were you present for discussions that Mr. Wright had with Ms. Love of the state?
No.
Okay. But to your understanding, some of the acknowledgements that you did not agree with, the state refused to change, correct?
Yes.
Okay. And you wanted to go home.
Yes.
Did you let a disagreement with those acknowledgements stop you from getting home to your sick mother?
Objection, speculation, and.
I said, did you let?
Objection as to the form of the question. Whether did you let that? Objection.
Can you rephrase your question?
Those disagreements with the acknowledgements, did you let those disagreements get in the way of you getting home to your sick mother?
No.
Objection, Your Honor.
I mean, you basically asked the same thing, the same way, you just moved the phrasing around. I don't really know. Can you rephrase it again?
Okay. Can I break it up?
You can try.
You disagreed with some of the factual acknowledgements that Ms. Love presented to you, correct?
Yes.
Okay. And you brought that to your attorney's attention.
Yes.
And you were told that the state was not going to change those factual acknowledgements.
Yes.
Okay. On December 28, 2022, did you let your disagreement with the factual acknowledgements stop you from entering that plea?
No.
Why not?
Because I wanted to go home to my sick mother.
15 months of
During
probation.
direct testimony, when Ms. Love was asking questions, you stated that you disagree with several of the factual acknowledgements in this plea agreement that you signed, correct?
Yes.
You watched the video of your plea earlier today, correct?
Yes.
Okay. Those acknowledgements on that video, who was reading those acknowledgements? Was it you or Ms. Love?
Miss Love.
Okay. When you were saying yes, ma'am, do you remember that? So
Yes.
pretty much every question, is that fair?
Yes.
Weren't there times during that plea, during that video, where you were saying yes, ma'am, before Ms. Love even asked the question?
Yes.
Why were you saying yes, ma'am, if you disagreed with the factual acknowledgements?
I was just trying to get home to my sick mother.
Okay. Did your attorney tell you, or you testified that your attorney told you that you could explain those disagreements later, correct?
If I was called into the stand, yes.
Okay. And You were advised not to let those disagreements get in the way of going home, correct?
Objection, Your Honor. Objection as attorney-client privilege, objection as to hearsay, objection.
You just gonna just say anything and see what stick on her.
Okay, sustained on facts not in evidence.
Okay. When you came to testify in front of this jury, you were under the impression that you would be able to explain what you disagreed with, correct?
Yes.
Do you know the saying, you're between a rock and a hard place?
Yes, I heard of it.
Okay. Do you consider yourself in between a rock and a hard place right now?
Yeah. Yes.
Okay. The rock is that you know some of these things in this plea agreement aren't true, correct?
Yes.
The hard place is you don't want to go back to prison, do you?
Yes.
Yes, you do not want to go
I
back.
don't want to go back to prison.
Okay. And the problem is your plea agreement, correct?
Yes.
Let's talk about this plea agreement. In this indictment, you were charged with 2 counts, correct?
Yes.
Count 1, RICO,
Yes.
or conspiracy to commit RICO, I should say.
Yes.
And count 30 was a gun charge, correct?
Yes.
Specifically, possession of a firearm by a convicted felon.
Yes.
For count 1, let's talk about that, what the plea agreement was, okay?
Yes.
The agreement, if you initialed the factual acknowledgments and entered a plea, the agreement was that the state was going to recommend 15 years of probation.
Yes.
And that meant that you would get out of jail immediately.
Yes.
I'm going to ask you to look at part 5 of the plea agreement, number 2, under defendant's sentencing acknowledgments.
Go Titans.
What page is that?
Let's go 12 o'clock.
That's page
Can't
5.
wait. Young quarterback. I don't know who else we got on. Oh, what's that dude? We got a
It's
fat ass
number
receiver
2
core.
under section 5.
Where does the running back position though?
Your agreement states that defendant, that's you, right?
Yes.
Defendant understands fully
Girl.
that if he violates any provision or any special condition of the plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections. And in parentheses, it says prison. Is that accurate?
Yes.
Okay, so let's break that down a little bit. You're aware that a condition of your plea is to testify consistently with the factual acknowledgments you signed.
Yes.
That you say are not true.
Yes.
And according to this agreement, if you fail to testify consistently with those acknowledgments, the state can move to revoke your probation, correct?
Yes.
Do you know what revoking probation is?
Yeah, I think take it back, take the probation back up, revoke it and see the privilege.
Okay, so if you have 15 years remaining on probation,
Yes.
the state can bring a motion and ask the judge to send you to prison for those 15 years instead of being on probation, correct?
Yes.
Let's talk about the agreement for count 30, possession of a firearm by a convicted felon. Okay. Your lawyer told you that count,
Sustained.
you were aware that count carries a mandatory 15 years in prison,
Yes.
and that 15-year sentence needs to be consecutive to any other sentence that you have.
Yes.
So it'd have to be 15 on top of the 15.
Yes.
On page 1, under negotiated sentence, it says, where it says count 30,
You said page 1?
yes, page 1, sir.
Okay. Yes.
It says, for count 30, that was the possession of firearm by a convicted felon, correct?
Yes.
says sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant, that's you, right?
Yes,
Has complied with the special conditions outlined in sections B, C, D, F, and I of Section 3, special conditions of sentence of this plea agreement, the state agrees the defendant shall be allowed to withdraw his plea on count 30, and the state shall agree to no pros count 30. That's what it says, right?
yes,
Okay, so let's talk about what your understanding of what this means. On December 28, 2022, you pled guilty to possession of a firearm by a convicted felon.
yes,
And under normal circumstances, that would be 15 years in prison consecutive.
yes,
But the state in this agreement allowed sentencing was withheld, correct?
yes,
So you weren't, even though you pled guilty to count 30, you were not given a sentence.
yes,
You were not given 15 years to serve in prison.
yes,
And sentencing was withheld until after this trial.
yes,
And your understanding is if you testify in accordance with this plea agreement, the state will dismiss that case.
yes,
Even though you've already pled guilty to it, the state will go back, let you withdraw your guilty plea, and dismiss the case.
yes,
You've been in trouble before, right?
yes,
Okay, you ever have an agreement, a situation like this in any of your other cases?
Sustained.
I'm going to ask you to look at part 5, number 4. Okay, and that's under defendant's sentencing acknowledgements.
Thank you for the dollar cash. Yeah.
Thank you, Sister Avanti, $10 coming on the Cash App. Thank you, sister. Next time, make it 20, but thank you for that 10. I know you barely had that. Thank you, sister.
Conclusion of the initial trial of this case,
Take the dollar
defendant
challenge.
fails or refuses to
Would anyone
testify
else
to
take
any
the
fact
dollar
that he acknowledges in his plea agreement. Such failure or refusal nullifies. Do you know what nullifies means?
no,
Okay. It says nullifies, all right?
yes, I say that, but I don't know what it means.
Nullifies any promise made by the district attorney to no pros count 30 of this indictment. Right?
Yes,
And to your understanding, regardless of whether you know what nullifies means, if you don't testify consistently with the factual acknowledgments that the state wrote,
yes,
they will take back their promise to dismiss count 30 and you'll be sentenced.
yes,
And you have to get 15 years in prison,
yes,
consecutive to the probation that would be revoked.
yes,
Can you look at number 3 under section 5? So I'm on page 5 now, going into page 6.
I'm with you.
Says defendant understands fully that any violation or of any provision or any special condition of the plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law.
Yes,
All that on that video talking about he has to testify truthfully. In your mind, who gets to determine whether you testify truthfully or not?
Objection, relevance, and objection improper. And they, who is to determine,
He was about to answer. He knows what I'm asking.
it's a binary question, whether it's true or not. Determining whether something is true or not.
Rephrase your question.
Who gets to revoke your who moves to revoke your probation if they're not happy with what you say here today?
listen,
Objection.
Why? It's
Unfair
true.
characterization. What is your objection?
One, yes,
If he
that
don't
I said who
testify
moves.
how they want him to, he can be locked up. It's in his plea agreement.
relevance is not a very characterization. And the terms of the,
It definitely is insane, E. Brooks, but if I had the choice between 15 years of probation and 15 years in jail, I ain't giving my probation. I would still be comfortable. I can eat what I want to eat. I ain't got to worry about dropping the soap. I can still get pussy. I would just do my 15. I'd be at the house, wouldn't do shit. fuck that. It is insane because the chances of you fucking up are astronomical, but I wouldn't even drive for 15 years. I'd catch an Uber or ride an e-bike every goddamn well. I would stay out of trouble. And then, see, he also, part of the 15 years was he had 2 charges. He had the drive-by shooting shit he pleaded guilty to. Then he had a felon in possession of a firearm. And all he got was 15 months of probation. And they dismissed the felon in possession of a firearm, which is fucking unheard of unless you helping with the DA out, which is what he did. 15 months of probation to testify, and we'll drop this goddamn charge. You testify, you pleaded this shit, so on paper it'll look like YSL a gang, and you cooperated, and you was the head of security, and you was riding around doing drive-bys for YSL and shit. And yeah, you can just do probation. Hey, I want to say his probation over with, ain't it? Yes, it was in 2022 when he took the plea. His probation is over, or it's about to be, but it should be over with. This nigga is free.
Agreement that Mr. Sledge entered into an argument for the jury, and the characterization that is being made at this point is improper. And I heard.
Sustained on the improper part. If you want to try to rephrase it.
Hello, Cold Pepsi.
Have you, in your life, have you ever seen a defense attorney try to revoke someone's probation?
Sustained.
Come on, Judge. Let us play. Let them cook.
Section 5, number 5.
The jury still heard. They're going to talk about you saying sustained.
Which?
Okay, and that's on page 7?
Yes, 6 and right.
Excuse me, you're right, 6. Thank you. It says, defendant understands fully that defendant's violation of the provision of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall not nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections / prison.
More than once.
So it says, right?
Yes.
Okay.
35.
We talked about 15 plus 15. That equals 30, right?
Right.
But in number 5, it's saying you're going to serve as much as 35 years.
Yes.
And even though that's an extra 5 years, you initialed it.
Yes.
Why did you initial it?
Because I wanted to get home to my mother.
He was coerced. The pressure was on him, as Rudy would say, the pressure.
I ain't understand whatever the word you've been using. I don't understand the words that
I'm using or that are in this document.
In the document, right?
Just for the hell of it, they added the extra 5.
I just want some clarity.
Yes.
Just because you fucked up.
You testified that you have a 9th grade education. You attended Southside High School, now Maynard Jackson High School, right?
Yes.
Okay. In the video, you said 10th grade. Is it 9th or 10th, or you?
I was actually trying to say I completed the 9th, but I was in 10th grade.
Okay. You ever receive any legal training?
No.
Okay. I'm going to ask you some questions. And I'm not asking what the acknowledgements say at this point, okay?
Yes.
Well, let me take that back for a second, okay? Just make sure we're on the same page.
Yes.
Okay. Let's talk about the acknowledgement. Now, number 3 on the factual acknowledgement says on page 3. You with me?
Yeah, I'm with you.
All right. Now, you testified that this acknowledgement is in fact false, correct?
Yes.
Okay. I'm going to read the acknowledgement with you, and then we're going to talk about the truth. Okay?
Yes.
The acknowledgement says, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, wherein defendant brandished a weapon used to drive in a drive-by shooting, and wherein, on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, parentheses, girlfriend.
Yes.
Okay, that's what it says?
Yes.
And so you see where it says, and to support, in the first line, I just going to reiterate, and to support and express loyalty to YSL. It says that in there, right?
Yes.
And it says, on behalf of YSL.
Yes.
Okay. Let's talk about that. Let's go. May I approach on?
You may.
Mr. Sledge, I'm showing you a document marked DS-36.
Yes.
Okay. Do you see that there's 3 pictures in that document?
Yes.
Okay. Can you identify the 3 people in those pictures?
Me, Antonio Sledge, and Trivia Smith, and what is name, Watson, or Kevin Watson, whatever.
Kelvin Watts?
Yes.
Is that also Shell Kel?
Shell Kel, yes.
You also call him Kel?
Yes.
Okay. Your Honor, at this point, I would ask to admit DS-36 into evidence.
Submitted.
Permission to publish, Your
Okay.
Honor. Spoken, will you please publish DS-36? Okay. Now, Mr. Sledge,
Yes.
we talked about how you're with the lady with the initials DB now, correct?
Yes.
Okay. Before DB, back in 2015, was there a young lady that you were involved with?
Yes.
Okay. And what was that young lady's name?
And Trivia Smith.
Okay. And what did you call her?
Treva.
Treva?
Yeah, Treva.
Treva. Okay. Do you see Treva in DS-36?
She at the top of the photo.
Okay. And do you see yourself in DS-36?
Right there to the left.
Okay. And who's the other gentleman in the bottom right on DS-36?
That's Kel.
Okay. Kelvin Watts?
Yes.
Okay. Do you recall when you started, how would you describe, in respectful terms, your relationship with Miss Trivia Smith?
How did I, at the time?
Yes.
It was great.
You cared about it.
Right.
Would you call her your girlfriend?
Yes.
Okay. When did you start dating, we'll say, Miss Smith?
I've been doing it since I've been dating since probably like 2009, but as the relationship, probably like 2013.
Okay, so by 2015, you've been in a relationship with her for at least 2 years, maybe longer.
Yes.
And you've known her for 8 years at that point.
Yes.
9 years.
Yes.
At some point, did she start dating another man?
From my understanding, yes.
Okay, and who is that other man?
Kevin Watson.
Okay, and do you know, was she dating, and I'm not trying to embarrass you, was she dating you first or Kelvin Watts first?
Me.
Okay. Do you know from your vantage point when she started dating Kelvin Watts?
I don't know at the time when she started dating.
Okay. And when you found out that she was dating Kelvin Watts, did you immediately break up with her and say, no, I don't have anything to do with you? Or did you keep having a relationship with her?
We kept conversation.
Okay. Did the fact that you and Mr. Watts were simultaneously dating Miss Smith, did that create problems between you and Mr. Watts?
Yes.
Okay. Did that lead to an internet back and forth between you and Mr. Watts?
Yes.
That had nothing to do with
At some point in 2015, did you hear that Mr. Watts was looking for you?
Yes.
And was all that revolving around your rivalry over Trivia Smith?
Yes.
Remember when the state played a video of you and Mr. Zachary with guns?
Yes.
Okay. You said it was childish, right?
Yes.
And at this point, Your Honor, I would ask for the state to publish what's 441Y. It's either 441Y or 395Y. 441 Yankee, thank you. Could you publish? Okay, thank you.
We ain't really gonna start that. We don't know nigga. You look bitch ass. I know me. Cam, fuck you, nigga. Cam, who else ass, nigga? Come on, nigga. Whoa. They say they ain't responding.
Okay, thank you. All right. Back in 2015, were you a little bit emotional about the situation?
Yes.
Okay. And in that video, that was posted on the internet, correct?
Yes.
Did you post it on the internet?
I think me or Zachary posted one. I was supposed to.
Okay. You intended for Mr. Watts to see the video.
Yes.
And in the video, you said you heard that Mr. Watts was looking for you, right?
Yes.
Okay. And you're in that video with guns.
Yes.
And you're in that video with Mr. Zachary.
Yes.
And that's Quindarius Zachary, right?
Yes.
Lil D from Cleveland.
Yes.
Okay. And that is someone that you have known since he was little, right?
Yes.
You grew up together in the Capitol Homes neighborhood in Atlanta.
Yes.
Apartments.
Yes.
How far did you grow up from him?
How far did I grow up?
That was a horrible question. You guys were both living in the same apartment complex, right?
Yes.
Now you're older than him.
Yes.
And he was a little boy at that time, right?
Yes.
Okay. Would you see him every day?
No, I wouldn't see him every day.
How often would you see him?
When I used to walk past his door to get to the basketball court, he'll be on the porch.
Okay. Are you particularly close with him? Or were you back in
At that time?
Yes.
No.
In 2015, you weren't?
Oh, 2015, we were very close.
Okay. And in that video, did you ever hear anyone say YSL?
No.
Did you ever hear anyone say gang?
No.
Did you hear anyone say on behalf of?
No.
Okay. Did anyone tell you to make that video?
No.
That was your decision.
Yes.
And you made that video because you were mad at Kelvin Watts because he was running his mouth?
Yes.
Because y'all were dating the same woman?
Yes.
Okay. So let's go back to factual acknowledgement 3, which deals with this video. It says, while associated with YSL and to support and express loyalty to YSL, did anything about making that video and talking junk to Kelvin Watts, did any of that video have to do anything with supporting and expressing loyalty to YSL?
No.
Okay. And then later on in factual acknowledgement 3, it says, and wherein on behalf of YSL, was there anything about that video that was done on behalf of YSL?
No.
Thank you. Okay. Let's talk about factual acknowledgement 5. It says, okay, let me back up. Factual acknowledgement 4, let's look at that. That's on page 3. You with me?
Yes.
All right. It says, on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant, that's you, right?
Yes.
And fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video, referenced in part 3 of this section, targeting family members of a rival gang. Okay?
Yes.
All right. And then on number 5 of the factual acknowledgements, it says, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4. Okay? Above, on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. See where it says that?
Yes.
Okay. And I'm just reading that. I'm not saying it's true.
You okay?
Okay. Okay, let's talk about that case. And that was 15 SC 138994.
Yes.
You were charged in that case, correct?
Yes.
Mr. Demekion Garlington was charged in that case, correct?
Yes.
And Mr. Quindarius Zachary was charged in that case, correct?
Yes.
No one else was charged in that case.
No.
And that night, April 28, 2015, I believe you testified you were at the Club Crucial.
Yes.
And Demekion Garlington was at Club Crucial.
Yes.
and you didn't go together, right?
No.
But you both happened to be there.
Yes.
And you're friends with Demekion Garlington, or you were at that time?
Yes.
Okay. And at some point, well, let me ask you one other thing. There were some young ladies at the club that you knew as well, correct?
Yes.
Alexis Bryant was at the club, right?
Yes.
And a young lady named Summer Good was at the club.
Yes.
And Summer Good is the girlfriend of Quindaria Zachary.
Yes.
Quindaria Zachary was not at the club.
No.
Okay. But his girlfriend was.
Yes.
Okay. And you indicated that Demekion Garlington was jumped by certain individuals.
Yes.
Okay. Did you observe the fight?
Not from the beginning, no.
Okay. On that date, did you know, while you were at the club, did you know who was jumping Demekion Garlington?
No.
Okay. Was this a major fight? Let me ask a better question.
Okay.
That was.
Okay.
Was this the type of fight where people were punching and kicking Demekion Garlington?
Yes.
Okay, and there were a lot of people at Club Crucial, right?
Yes.
A lot of other people you knew.
Yes.
Demekion, you said you left the club without Demekion Garlington.
Yes.
Okay. But then you received a call from Demekion Garlington.
Yes.
And the reality is Demekion didn't have a car.
Yes.
Okay. You had a car.
Yes.
Right. So Demekion asked you to pick him up.
Yeah, he asked me to come back and pick him up, yes.
Okay. Demekion was upset, correct?
Yes.
Was Demekion drinking that night?
I can't tell you if he was drinking that night. He probably wasn't even in the club that long. So I don't know if he was drinking.
You know if he was using drugs, popping pills, anything like that night?
Probably before he got there, but I didn't see him popping the pills.
Okay, were you drinking that night?
Yeah, I was drunk.
You said you were drunk?
Yeah, I was drunk. Yeah, drunk, yeah.
Okay. So Demekion is upset after getting jumped in the club, and he calls you to come pick him up. And you're drunk, and you think he might have been popping pills and don't know what else, right?
Yes.
Demekion had been publicly humiliated, right?
Yes.
When you guys were driving from the club, Summer Good and Alexis Bryant were following y'all's car, correct?
Yes.
They were leaving the club at the same time.
Yes.
And again, Summer Good being Quindaria Zachary's girlfriend.
Yes.
And to your understanding, Summer Good was scared.
Yes.
Because people were following her car.
Sustained.
Okay. Well, it was your car and Summer's car. Was there another car following behind y'all?
Yes.
Okay. And Quindaria Zachary, who wasn't in the club, was called about the situation, correct? Well, you went to pick up. Okay, you went to pick up Quindaria Zachary, right?
Yes.
Okay. And the purpose of you picking up Quindaria Zachary was to take him to the house where Summer Good was.
Yes.
To protect her.
Yes.
Yeah, objection.
It's going to be, she knows the discovery. It's going to be completely obvious.
Well, I mean, it's happened at this point. Let's kind of get to whatever it is that you're trying to get to here.
Summer Good was at a house at Alexis Bryant's house on Landrum Drive, correct?
Yes.
And you and Demekion Garlington, this is after the fight, picked up Quindaria Zachary and drove to that house on Landrum Drive.
Yes.
Where Summer Good was.
Yes.
Okay. And when you all arrived at that house, you saw someone shooting at that house.
Yes.
Shooting at the house that Summer Good and Alexis Bryant were in.
Yes.
You were driving the car, right?
Yes.
Not the car that was shooting. You saw a car shooting and you're driving in a car pulling up.
Yes.
Okay. You chased those people off that were shooting at the house, correct?
Yes.
Okay. At some point, and I think your testimony is that you don't know who they were, but one of the other individuals in the car, your car, determined who was shooting at the house that Summer Good was in, correct?
Yes.
And it was determined that you were to drive them to the house where those people stayed in.
Could you repeat that? Could I understand?
And I asked in a bad way. You're in a car, and it was determined someone, not you, but someone felt they knew who was shooting at the house with Summer and Alexis, right?
Yes.
Okay. And then you ended up driving to a house.
I don't think I went to another house after that, Mr. Shaw. I'm not for sure.
Well, let me back up. In your testimony, you said your testimony was you drove Quindarius Zachary and Demetrion Garlington to a house, right?
Yeah.
And they had guns.
Yes.
And they got out and did whatever they did to that house.
Yes.
Okay. That wasn't the house that Summer Good and Alexis Bryant were in on Landrum.
No.
Okay, so after you saw that house, the first house where Alexis Bryant and Summer Good were being shot at, you drove to another house where Demetrion and Quindarius did whatever they did. Right?
Yes.
Okay. And you pled guilty to that.
Yes.
You don't know who jumped Demetrion Garlington.
No.
Okay. You drove to the first house on Landrum where Summer Good was because Quindarius Zachary wanted to protect his girlfriend.
Yes.
And once you saw people shooting at the house, Demetrion Garlington and Quindarius Zachary wanted revenge, right?
Yes.
Quindarius Zachary wanted to go back at the people that were shooting at his girlfriend.
Yes.
And Demetrion Garlington wanted to go back at the people who he felt jumped him in the club.
Yes.
Okay? That was personal revenge, correct?
Yes.
In retrospect, you're 43 years old.
Come on.
Okay?
Come on, the
You know
OG.
Quindarius Zachary since he was this big.
Yes.
You know Demetrion Garlington, I believe you knew him since he was a baby too, right?
Yes.
Okay, in retrospect, you were the older person in the situation, correct?
Yes.
You should have known better than to drive them anywhere, right?
Yes.
Okay, but you did.
Yes.
Okay, but the bottom line, and you pled guilty,
Yes.
and you served your sentence.
Yes.
The bottom line is Jeffrey Williams didn't instruct you to go drive to any houses at night.
No, Jeffrey wouldn't know nothing about it.
Okay.
Objection is to speculation about what someone else.
Sustained.
Ask that question.
Okay, you don't know what Jeffrey Williams knew on any given night, but he didn't order you to go to any house.
No. No.
Okay. And no one was out the window shooting guns, yelling, YSL, YSL.
You ask compound questions.
No.
The fuck? All your questions was compounded.
The reality, Mr. Sledge, is what happened on April 28, 2015 was done on behalf of Demetrion Garlington, who got jumped in the club.
Yes.
Was done on behalf of Quindarius Zachary, whose girlfriend was getting shot at.
Yes.
It was not done on behalf of YSL.
No.
It was not done to increase the notoriety, reputation, or fear of YSL, was it?
No.
Okay. The state asked you about, I'm on page 5, Mr. Sledge, number 14 and 15. Okay. And I'm gonna read those in a second, but I just want to ask you some questions. Okay. We already established it. Did you grow up, Mr. Sledge?
Yes.
We'll get to that in a second.
Okay.
I want you to listen to my question. Okay.
Yes.
Thank you. You grew up. We've established that you lived in Capitol Homes. Did you grow up in Capitol Homes?
Yes.
Okay. And Capitol Homes, does that still exist, or has it been torn down by now?
They tore down, but they call it something else now. Capitol Gateway or something like
Little
that.
Gateway.
Yeah.
Okay. Could you help me understand what area of town, what street is Capitol Homes on?
Memorial Drive.
Okay, it's on Memorial Drive, maybe 5 minutes from this courthouse, right?
Yes.
They made it nicer now,
Yes.
but back then it was rough neighborhood, right?
Yes.
And then, how long did you live at Capitol Homes? To what age?
I don't remember exact how old I was, but whatever year they got tore down.
Were you a teenager or?
Yeah, I was a teenager.
Like,
I probably was grown.
so if you were a teenager, we're talking about 18, 19, not.
Yeah.
All right. And then eventually you ended up living off of Boulevard, correct?
Yes.
Okay, did you go straight from Capitol Homes
To Boulevard.
to Boulevard? And when we say Boulevard, we're talking like the Bedford Pines?
Yeah, Bedford Pine Apartments.
Okay, those are right by the intersection of Boulevard and like North Avenue, right?
Yes.
Okay, great. East side of Atlanta.
Yes.
Okay, both these places, Capitol Homes and Boulevard, are, well, you tell me, how long do you think it would take to drive to Cleveland Avenue?
I can't give you exact how long, but if my mind record, probably about 15. Probably 15 minutes from Capitol Home, probably about 19 from Boulevard, 20 somewhere there.
Okay. Bottom line, it's not the same neighborhood.
No.
Miles apart.
Miles apart.
Okay. Have you ever lived off of Cleveland Avenue?
Stay off of Cleveland Avenue.
Or on Cleveland Avenue, or stayed off of Cleveland Avenue?
Yes.
When was that?
I want to say it was probably like 2008, 2009, somewhere in that area.
Okay. And for how long? I'm not asking for an exact address. You live off in the Boulevard area now, right?
Yes.
Okay. So how long did you stay on Cleveland Avenue?
Not long. Well, my kids stay over there, but I actually moved to Boulevard.
Okay.
But my kids and their mother still staying over there, so I used to go over there.
Okay, so you used to go over there.
Yes.
And I'm asking you, okay, correct me if I'm wrong, did you ever formally live over there?
No.
Okay. Now, I hate to ask you this, but you've been a drug dealer before in your life, right?
Yes.
Okay, you have a history of, your criminal record reflects that, correct?
Yes.
Okay, you've been arrested for selling drugs downtown Atlanta.
Yes.
Okay, you've sold drugs in the past. I'm talking about the past, off of Boulevard.
Yes.
Okay, you've sold drugs around many areas of Atlanta, correct?
Yes.
Okay. You talked about hanging out in these gas stations, and you said your testimony, as I recall it, was that sometimes you would hang out in the gas station with your own personal bag.
Yes.
And if people wanted a little bit off your personal bag, you would sell it to them.
Yes.
Okay. And you would hang out with Christian McMiller and Darius Ford.
Yes.
Okay. Personal bag, we're talking about bag of marijuana?
Yes.
Okay. And we're talking about if someone, for me, for instance, asked you, hey, can I buy some of that marijuana off you? We're talking about $5, $10 type stuff, right?
Yes.
Okay. Petty.
Yeah, something.
Okay. Do a lot of people sell drugs out of gas stations in your experience? As foot traffic, right?
Relevance as to whether or not a lot of people.
Sustained.
Have you sold drugs in gas stations before?
Yes.
Okay, you sold drugs in gas stations downtown, right?
Yes.
Whether it's so gas, drugs that don't gas.
It's relevant, not.
Yes.
You sold drugs at gas stations off of Boulevard before, right?
Yes.
Okay. And your testimony is that you would occasionally hang out at some gas stations on Cleveland Avenue with your personal bag of marijuana.
Yeah.
With your friends, Big and Neckman.
Yes.
Okay. Would you be there 24/7?
No.
Okay. How many times would you say total that you hung out at these gas stations? Is it more than a dozen?
Yes.
More than 2 dozen?
Yes, probably more, yeah. I pull up and just kick it and then leave.
Okay, when you say you would pull up and kick it and then leave, is it fair to say that you were not part of some complex drug distribution network in these gas stations?
No.
Okay, so when you would just kick it and leave, we're talking about you staying around for how many minutes?
Sometime an hour, less.
Okay. All right. And you say, you thought, I want to get this right, you thought maybe more than a couple dozen, more than 25
Yes.
times total?
Yes.
Sometimes stay for like an hour?
Yes.
You'd also hang out at the park,
Yes.
hang out at other stores.
Yes.
That's where the mother of at least one of your children lived.
Yes.
Okay. That area, not the gas station.
Yes, that area.
All right. And from your observation, and I know you don't want to speak on this, so I'm going to keep it brief. Your two friends would sell drugs at those gas stations.
Yes.
They sell drugs other places too, right?
Yes.
Okay. Tell me about the time that you and Christian McMiller and Darius Ford pulled out AK-47s and chased everyone out of the parking lot to protect drug turf.
Never.
Okay. You just observed two people selling weed at a gas station before.
Yes.
Okay, let's go back to your factual acknowledgments that you signed on December 28, 2022. The gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Okay, now, it is true that in your mind, Darius Ford and Christian McMiller were YSL associates in your mind.
Yes.
And they would sell drugs at these two gas stations, 151 Cleveland Avenue and 221 Cleveland Avenue, and a bunch of other places, correct?
Yes.
Okay, but you haven't seen anyone do anything that would lead you to believe that they did not allow other gangs to operate in those gas stations, did you?
No.
No violence,
No.
no attacks.
No.
The factual acknowledgement that the video about Shell Cal had something to do with YSL, that was incorrect.
Yes.
The factual acknowledgement that the shootings on April 28th, 2015 were done on behalf of YSL, that was incorrect.
Yes.
The factual acknowledgements that YSL associates do not allow other gangs to operate at these two gas stations, those were incorrect.
Yes.
These money that you would make selling little $5, $10 bags, whatever, of marijuana, would you run to Jeffrey Williams and give him those $5 bills, $10 bills?
Never.
Okay, would you run to Shannon Stillwell and give him the $5 and $10 bills?
No.
I don't know. I think he's doing a good job
Mr.
of cross-examination.
I'm going to ask you to go to page 6 or 7 again. Okay, let me ask you, before you sign these documents on December 28th, you moved for bond on this case, correct?
Yes.
You moved for bond on October 13th, 2022, correct?
Yes.
And the state opposed your bond, right?
Yes.
They said that you were a danger to the community.
Yes.
They said you were a threat,
Yes.
and you were denied bond.
Yes.
That kept you away from your family.
Yes.
On the bottom of page 6, it says, the last sentence, I freely, knowingly, and voluntarily entered into this agreement without force, threat, or coercion. And we already said you didn't know what coercion meant.
Yes.
Let's just say pressure.
Yes.
That's not true, is it? You were pressured.
Yes, I was pressured.
He was applying pressure.
In fact, you were pressured into signing a document that claims that you're entering the agreement without pressure.
Yes.
We talked about that bond hearing before December 28th, where the state called you dangerous, too dangerous to release.
Objection, Your Honor, one fact, evidence too improper.
He was there.
And irrelevant.
He was there. Did they call you? It's not for the truth of the matter asserted, it's for the state's stance.
Objection, Your Honor. State
Very well.
regarding a bond matter.
or this witness has no relevance or bearing on the guilt or innocence of either of the defendants here?
No, it doesn't, but I don't think that's what he's offering it for. I'll permit it.
They told you, they said to the judge that you were too dangerous to let go, right?
Yes.
When you initialed these acknowledgements that they wrote, they gave you probation, right?
Yes.
And then something came up.
And
Because-
I'm sorry, I know that the objection needs to be at the same time, but as I thought about it, that was hearsay as well. What the state told him about his dangerousness or whatever you.
I'm not saying it's dangerous.
Literally, the question was, did the state say that you were too dangerous to let go? That's hearsay. There's no, that's hearsay.
It's not for the truth of the matter, sir.
Overruled.
Again, they said, not saying you're dangerous. They said you were too dangerous to let
Objection,
go.
already asked.
Well, I'm trying to recap because I keep getting interrupted.
Well, she's entitled to interrupt you if she thinks she's got a legitimate evidentiary objection.
Okay. After you initialed these documents, next to the statements that they wrote, they gave you probation on count 1, right?
Yes.
Objection, asking me.
Okay, sustained.
And something came up in court because you pled guilty to count 30, but weren't being sentenced. You had to be given a bond on that in order to be released.
Yes.
And all of a sudden, on December 28th, after you initialed these statements, the state recommended a signature bond. Isn't that correct?
Yes.
A signature bond means you get released and you don't even have to pay any bond at all, right?
Yes.
And they can recommend this anytime. They typically don't.
Have you ever been able to figure out what made you so dangerous before December 28th?
Sustained.
I have no further questions. Thank you.
All right. Jody, I'll need a break before we move on to the next cross.
Mr.
Let's take a
Still
10 minute or
coming
so
up.
break.
All right, concerned?
Shane Ted don't have one. He didn't give it time. Been that long, no? He's still in the 6 hours. Yeah. Just under 3 hours to go. We ride. I wonder how many more breaks they're gonna take. We skip till they actually start talking to this nigga. He's standing there drinking water.
Four, it's Mr. Williams, exhibit number, of what you called it? The rodeo. Behalf of YSL.
Yes.
Okay, and you initial.
Yes.
Did Miss Love ever ask?
Damn, I skipped 2 fucking far.
Anything about?
Yes.
On the same document?
All right, go ahead, Mr. Steele.
Mr. Sledge, on number 3 that we were just talking about?
Yes.
On the same document?
Yes.
During your time before Judge Glanville entering the plea and Ms. Love was asking you questions?
Yes.
Saw the video, audio of that as well?
Yes.
Did Ms. Love ever ask you anything about Jeffrey at that point?
No.
And you were under oath at that point?
Yes.
And you were going to answer questions if asked, right?
Yes.
I'd like to go to number 4, same page.
Yes.
On or about April 28th, 2015, as reflected in Fulton County indictment number, and I'm not going to read it, but it ends in 8994. You see what I did?
Yes.
I just skipped the first bunch of numbers and letters. You and fellow YSL associates, Mr. Garlington and Mr. Zachary, committed a drive-by shooting using a firearm, the firearm that you.
Hey, which speaker died? Had to be the main. Yep. Hold on, y'all.
December
I gotta
28th,
grab the charge.
2022, under oath from the court reporter on
It
the
might
video
cut off
about
again.
Number 5, same page, same document. You and your fellow YSL associates can.
Son of a biscuit eater, they cut off again. I knew it. Wait a minute. All right. Now.
Or above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, okay?
Yes.
Were you asked anything on December 28, 2022
Hey, Miss
about
Tia.
that?
Left channel.
Answer questions asked, right?
Right channel.
By this time, April 28, 2015, if you personally know, did Jeffrey launch a tour across the United States of America with Travis Scott?
I think it was around that time, if I'm not mistaken, I'm not for sure.
You went on part of that tour?
Did I go on board? Yes.
On part of the tour?
Yes.
And you told the jurors what it's called. Do you remember what you called it?
The rodeo tour.
With the court's permission and your permission, I'd like to approach you with a document, okay?
Yes.
Your Honor, may I approach?
Yeah.
Ms. Winfrey, may I approach and get that done?
I will ask him back to you.
I'm sure he'll show you.
Guys, this is already been shown.
Damn, y'all talking about it already.
Partially admitted as on 1/8/24, so the January 8th, 2024, it's Mr. Williams, exhibit number 19.
All right, I'm not sure what you mean by partially admitted.
Parts of it were admitted.
Okay, are you
Not-
admitted
yes.
to the admission of the rest of it?
Yes, I'm going to see if Mrs. Sledge can identify that.
You may.
Yes, I'm going to show you an item, and I added that earlier, so that's just called an exhibit sticker. Yeah. But if you can look at that, you can open it up. Just tell me if you recognize it, and if it is accurate. If you don't recognize it, that's fine, and we will. We're going to put it aside, okay? So.
Yeah, I remember this.
And what is that document, which I believe is number 19 of Jeffrey Williams?
This is the
Put it
booklet.
down until it's admitted.
Okay, I'm sorry.
Okay.
This is the booklet of the tour on what days and what areas that we was in.
Okay, and does it look to your memory to be accurate? Meaning, has it been changed in any way? Has it been altered, or does it look similar to the way that you saw it when you went on that tour?
It looked the same.
Your Honor, I move for the admission of Mr. Williams. It's number 19.
Your Honor, pursuant to 21-801. I object on the grounds of hearsay.
For what purpose is this being offered?
The purpose of showing the cities and the states for this certain tour.
And the dates?
That's what it is.
And
That's all it is.
Your Honor, that he's describing is already just that portion.
It's there. That's the official tour guide to that tour.
The testifying, but there is a portion we can show the court.
Okay, well, I may need to see it myself then, because I don't know what
Okay,
might be problematic, yes.
Yes.
Can you hand it to me?
Do I need that?
I think Mr. Steele should probably come up also.
Don't we step out?
Yeah.
Well, that didn't last long. They huddled up quick.
Mayor Pro Tem?
You may. So the portion for the ruling is that it was already in, is in.
Sledge, Mayor Pro Tem? Yes. And turn to the third page, okay, to turn to the sixth page, if you count both sides of this link number 19. Do you see any dates of that rodeo tour? Yes. And can you tell the ladies and gentlemen jury, just read it to them, if you don't mind, the date and the city of the tour? Wait, from the top.
Entirety of the tour dates?
Sure.
Do you want to just post that page?
I don't have it on the.
Okay.
Yeah, also, this witnesses, basis for knowledge of the specific dates, we would object unless there is a foundation laid for that.
Okay, well, he said he went on parts of this tour and was familiar with the tour.
Mr.
So
Sledge,
overruled.
do you feel comfortable doing that? And if not, just.
Yes, I can read you the dates and.
Actually, you're on man approach?
You may.
Man approach you, sir?
Yeah.
Would you mind if I read along with you?
Yes.
Okay, you just tell me if you can put it down. I don't have very good eyes. All right, I'm going to start here, okay?
Yes.
Saturday, February 28, 2015.
Yes.
Santa Ana, California.
Yes.
March
15.
Sunday, March 15, March 1, 2015. See that?
Yes.
Santa Ana, California show day.
Yes.
Monday, March 2nd, Tucson, Arizona show day.
Yes.
Yes.
I don't know if there's a question, and I would object to Mr. Steele.
Can we maybe give a summary of it?
Okay. Then the next one is the next day. It's a travel day, right?
Yes.
And then it's March 4th, 2015, Denver, Colorado show.
Yes.
And then I'm skipping. March 6th, 2015, Milwaukee, Wisconsin show.
Yes.
It's the same thing, it's the same. Testifying is not a question, it's a statement.
So
This is in evidence.
he's confirming the dates. I mean, Mr. Steele is not testifying, so that's overruled.
Saturday, March 7th, 2015, Chicago, Illinois,
Yes.
show day, and Rochester, New York as well.
Yes.
Sunday, March 8th, 2015, Chicago, Illinois, a show day.
Yes.
Monday, March 9th, 2015, Detroit, Michigan, a show day.
Yes.
Tuesday, March 10th, 2015, Toronto, Ontario, Canada, a show day.
Yes.
Wednesday, March 11th, 2015, Buffalo, New York, a show.
Yes.
Thursday, March 12th, 2015, New York, a show.
Yes.
Or a concert.
What month are you going to get to before the list is over with? Can we just say there were show dates that's constantly between X date and Y date?
Sure. It goes up to, is it fair to say, consistently through April 3, 2015. Is that true?
Yes.
And the cities that we left off at include Philadelphia, Pennsylvania,
Yes.
Washington, D.C.,
Yes.
Norfolk, Virginia,
Yes.
Charlotte, North Carolina,
Yes.
great city of Atlanta, great state of Georgia,
Yes.
New Orleans, Louisiana,
Yes.
Austin, Texas,
Yes.
San Marcos, Texas,
Yes.
Houston, Texas,
Yes.
Dallas, Texas,
Yes.
Phoenix, Arizona,
Yes.
San Diego, California,
Yes.
Los Angeles, California,
Yes.
San Francisco, California,
Yes.
Seattle, Washington,
Yes.
Portland, Oregon,
Yes.
Boise, Idaho,
Yes.
travel home.
Yes.
Okay. Now, I know if you need to see it, just let us know. Now, knowing Jeffrey Williams since about 2009 when you were released from prison,
Yes.
and seeing him on tour throughout our country, how much time did he spend committing crimes on
Objection,
Cleveland Avenue?
objection. Holding improper and speculation and speaking as to a legal conclusion committing crimes that this witness should not.
Sustained.
Did District Attorney Love was having you, where you agreed, sign that on April 28, 2015, it's number 5, that this drive-by shooting on April 28, 2015 was done on behalf of YSL to increase the notoriety, reputation, and fear of YSL. How many questions did she ever ask you at that time you were entering the plea, sworn under oath, about Jeffrey Williams?
The number of questions that were not asked about a specific defendant. It's irrelevant how many times you asked, the jury can see what happened and what was asked.
Sustained.
By April of 2015, how wildly popular from your personal observation is Jeffrey Williams?
Objection, relevance.
Overruled.
Very popular.
When you went to all of these cities throughout America with Jeffrey, how many fans would come?
Objection, speculation, and relevance.
I mean, if you can estimate it, overruled on relevance.
20 to 30,000, a lot of people. Okay.
Were these concerts held in arenas?
Yes.
Number 6, it's on page 3, it goes into page 4, okay? Same document.
Page 6.
Going into, it's number 6, it's on the bottom of page 3,
Okay, yeah.
same document. It's going to go into the next page, okay?
Yes.
You admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, and it goes on to the next page, for your participation in the drive-by shooting, and it says reference in 3, 4, and 5 above, meaning the April 28, 2015, right?
Yes.
Okay. Number 7, it says that you were told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia to discuss the murder, right?
Yes.
Anyone ever asked you any evidence that Jeffrey was at the McDonald's?
Objection, improper question as to evidence. Did anyone ever ask?
Sustained.
Did Miss Love on December 28, of 2022 ask you, was Jeffrey at the McDonald's?
Objection, again, one relevance. The jury has already seen what was asked and not relevant and improper question.
Oh, that's overruled.
Okay,
Okay, so the entirety of the plea transcript is not actually in there. I don't know, what number are we on right now? 6? 7?
Yes.
So,
7 is in there.
okay, but we don't have the entirety of it. Overruled.
Did District Attorney Love ask you on December 28, of 2002, was Jeffrey at the McDonald's?
No.
You have any evidence that Jeffrey was at this McDonald's?
Objection as to that question.
Sustained.
Do you know personally, or what you were told is reference in number 7, was Jeffrey at this McDonald's?
No.
Number 8, you personally know that one or more YSL associates committed the murder of Donovan Thomas on behalf of Jeffrey. That's what you signed, right?
Yes.
Okay. Do you have any personal knowledge that Jeffrey Williams committed the murder of Donovan Thomas Jr.?
No.
In any fashion?
No.
You know what a party to a crime is? You know what that means?
Overruled.
Yes.
Was Jeffrey, do you have any information?
I mean, I'm sorry, sustained, sorry. You may not ask that question. It just feels like, sorry, my bad.
He said, oh,
Finally,
Number 9.
finally, she moved.
See where I am, number 9?
yes.
January 10, 2015. After the murder of Donovan Thomas Jr., you and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave you and other YSL associates cash money to lay low. You see that?
Yes.
You already told the jury, you made it clear that Jeffrey did give you $300. True?
Yes.
Because you feared for the safety of yourself and your family, right?
Yes.
Did anybody fire weapons, bullets into your home where you were living on June 10th, 2015, or the 11th, or the 12th, or the 13th?
No.
And then even after you received these, I think you called it anonymous statements that you and Mr. Copeland killed Donovan Thomas, you used some word. It was from an account, social media.
Yes.
What was your word?
The DM.
Yeah. Was it from what'd you say?
A fake page.
Fake page. Okay. When you got that though, you made it clear that that bothered you because you didn't want anything to happen to your significant other or your child or anybody, right?
Yes.
Including yourself.
Yes.
And you didn't have money at that time because you lost money gambling. Is that true?
Yes.
And You asked Jeffrey and he gave you money for a hotel, right? Yes. And the expression lay low, I know you said it was to get your family members out of harm's way. I think that's what you said. Yes. But lay low could mean the same, doesn't it? Yes. It wasn't any type of lay low from the police or anything, right? No. It was be safe. Yes. Do you have any information, personal knowledge to share with the jury that Jeffrey gave any money to anyone as a reward for killing Dr. Thomas?
Objection, Your Honor, that would call for speculation and hearsay as the reward part.
Overruled. And actually be overruled.
No. I'm going to go to number 10, if you don't mind. Same document, page 4. That you have personal knowledge that on January 10, 2015, after the murder of Donovan Thomas, YSL associates traveled to Miami, Florida, with co-defendant and YSL founder Jeffrey Williams, aka Young Thug. I want to talk to you about that, okay? Yes. And you made it clear that you knew that Jeffrey Williams was already going to Miami, Florida for a video music shoot. Is that, when I say shoot, filming it? Is that true? Yes. And you knew that this was already set up before January 10, 2015, right? Yes. And you knew other people were allowed to go if they wanted to. Yes. That Jeffrey was generous. He would take people outside of that.
Objection, Your Honor, as to character evidence that is going to.
Sustained, rephrase.
Jeffrey Williams gave people the opportunity to leave Cleveland Avenue area and see other parts of America. Is that true?
As to relevance and whether or not Mr. Williams gave anybody else an opportunity to use something.
Sustained.
Mr. Williams gave you opportunity to go, right? Yes. And others? Yes.
Objection, Your Honor.
Was there anything that on the 28th day of December 2022 that you were asked as to why this was somehow criminal, that Jeffrey had this meeting, this work in Miami, Florida?
Objection, Your Honor.
Sustained.
Were you asked any questions by District Attorney Love, Judge Glanville, or anyone, whether that going down to Miami, Florida, was not pre-planned? No. Number 11 says that you did not murder Donovan Thomas Jr. and you're not a party to that crime. That's true, right? Yes. Number 12, that you did not murder Mr. Drinks and not party to a crime. True? Yes. Okay. Number 13, on the bottom of that page, it says, you cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas Jr. are not guilty of murder, and you will make no attempt at trial, prior to trial or after trial, to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. You see that? Yes. Okay. Now you've read this indictment. You've had it because you were charged in this case. Is that true? Yes. Are you familiar still with this indictment? Yes. Okay. Well, if you need it, with the court's permission, I have a copy if you need to see it. But you're not charged with the murder of Donovan Thomas in this indictment, are you? No, not in this indictment. Okay. And you're not, and Jeffrey's not charged with the murder of Donovan Thomas in this indictment, right? No. You're not charged with the murder of Mr. Drinks in this indictment, are you? No. And Jeffrey's not charged with the murder of Mr. Drinks? No. If you go to page 5, it's the top of page number 14. The gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. You see that? Yes. And then I'm just grouping it together because they look similar to me. So if they're not, just correct me. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate. Right? Yes. You ever asked any questions about Jeffrey selling drugs at either of these items?
I object on the grounds that still has no good faith basis for asking that question, given the fact that the entirety, he does have the entirety of that, and he does know the entirety of that. And so therefore, 1 is not relevant, but 2, he doesn't even have the faith basis for asking. So if we want to get into the entirety of what was asked, I would ask that the court just simply, if he wants that in, have him tender it, but not to ask questions that he knows he doesn't have the faith basis to ask.
I don't know what that means. It was not asked. And I'm asking the gentleman whether he was ever asked that. On the record, off the record, it's not there.
Okay. I don't know if you meant on the record or off the record, but I'm going to permit it. Go ahead.
Have anything to do with Jeffrey?
No,
You asked anything from District Attorney Love when she had you under oath in a courtroom with your lawyer before Judge Lamb?
no,
Number 15. You have personal knowledge that you and other members of YSL have either participated in, directly committed, or at least one of the following crimes in order to increase notoriety and reputation of YSL: murder, armed robbery, assault, attempted murder, theft, illegal gun possession, and illegal drug and sales. Did you ever ask anything about Jeffrey on December 28, 2022 when you entered this plea?
no,
Now, you have been prosecuted before this case. By prosecuted, I mean you've been arrested, charged, and brought before a judge, right?
yes,
Okay. Have you ever, in your experience, have you ever been told that your plea agreement is conditioned on what you say in the trial?
no,
Have you ever been told by a prosecutor that you prefer you not say things in front of the jury?
Your Honor, I object on the basis of relevance and
God damn, every time you say something, she objects.
Relevance and what? I'm sorry, did you say something else?
the question was, have you ever been told by the prosecutor something? So I object on the basis of relevance. I'll stop at relevance.
Mr. Steele, would you like to address that?
Sure. Goes to the motivation, interest, and bias of the district attorney in this case.
Well, that's not an issue.
It always is an issue.
It always is.
Telling a witness.
Bias of his witness, maybe.
Come on, White Johnny.
Is that what you need to say?
It's a party opponent.
No, sir, that's not how that works.
Okay.
So if that's your only justification for it, then grant it. I mean, sustained.
Damn it.
Okay, I want to talk to you about
She keep fucking up. It's a long day.
when you met Jeffrey, he was approximately 17 years of age. Is that fair to say?
yes,
And it's about 2009.
yes,
And the way you remember 2009 is because you were in prison and it was released in about 2009. Is that true?
yes,
And then you went over and found a place to live on Cleveland Avenue.
yes,
So you met people who were in that area. Is that fair to say?
yes,
And Jeffrey was at times in that area, right?
yes,
Did you observe Jeffrey working hard?
Objection phase.
Okay.
Sustained.
Did you observe Jeffrey
Damn, Judge.
practicing his craft art music?
yes,
Did you see him in the studio? Did you ever see him in the studio?
yes,
And is it fair to say that when you first saw him, to however long you've known him, he is a workaholic? I mean, he works all the time.
Objection, Your Honor.
What the fuck?
Speculation, workaholic, full characterization, so objection on basis of relevance, phase.
God damn.
I think I'm relevant,
can't even ask
sustained.
a question.
You've seen him in studios in the morning time,
yes,
afternoons,
yes,
nights,
yes,
evenings.
yes,
You mentioned on direct examination that Jeffrey idolized Lil Wayne. You remember saying that?
yes,
And that there was this, these are my words, so you correct me, there's almost this belief, this feeling that Jeffrey had that he had to make it out.
Defendant Williams' feelings.
Sustained.
You said on direct examination, when you were questioned by Ms. Love, that you believed that Jeffrey was going to be
Objection,
a
objection, Your Honor.
popular.
Objection as to one, relevance of the witness's beliefs about something he may have speculated about regarding defendant Williams.
Sorry, I don't know because I haven't heard the question. Can you tell me what the question is?
Sure, and it came out on direct, that there was a belief by Mr. Sledge that Jeffrey was going to be a successful musical artist.
Okay. and
Way back when.
What's your question gonna be?
That, I'm going to follow that up. That was his drive. That was Jeffrey's mission, his drive.
Objection, not only speculation as to defendant Williams' innocent and.
No, he's asking about this witness's belief about that, but that's irrelevant.
Come on, Judge.
All right.
Killing
Now.
it here.
Have you ever observed anyone,
She got away with. Overruled.
or have you observed Jeffrey, when you first met him? You got out of prison, I think, May 2009, is that right?
Yes, that's correct.
He played in a lot of first local clubs, is that right?
Yes,
When I say local clubs, in the area of Atlanta.
yes,
And then you saw it go a bigger location, is that true?
yes,
And then multiple states?
Objection, Your Honor, relevance.
This is his career.
Go ahead.
yes,
And people, including you supported Jeffrey's musical career, didn't you?
Objection as to that compound question, because it causes speculation as to people supporting, employees, and it's not
It's
relevant.
personal observation.
Okay, sustained on other people and sustained on relevance.
Damn it.
Would you observe, I mean, did you personally observe the local community in Cleveland Avenue come out to Jeffrey's shows?
Objection, relevance.
Sustained.
Would you see people, including yourself, put up signs that Jeffrey's performing?
Objection, relevance.
What's
Sustained.
the fuck?
Move on to another topic.
All the people that you were asked about, remember being asked about Trontavious Stevens
yes,
and Mr. Murphy,
yes,
Mr. Murphy, and Mr. Copeland,
yes,
Being handcuffed.
and whoever you were asked about, okay?
yes,
All those people were in poverty at the same time you and Jeffrey were, right?
Objection calls for speculation, and it is irrelevant, and is compound as it relates to, at the same time, you and Jeffrey, and assumes facts that are not evidence.
Sustained.
Were you in poverty in 2009 when you met Jeffrey?
Overruled.
could you repeat the question, Mr.?
Yes, sir. Were you poor? Were you struggling financially in 2009 when you got out of prison?
Yes,
All those other people that you're asked about in direct, were they struggling to your observation
yes,
financially? Jeffrey gave you a job, right?
yes,
And by that
Object.
job, you called yourself, and I'm not saying that was not your title.
I object
But-
to this line of questioning regarding.
You got it, damn it.
It's meaningless.
I knew it was coming.
You were called head of security, right?
yes,
And by that, what that meant was that you would assist others in
We've
locating.
established what it meant.
I'm sorry.
We've established on direct what it meant, what his duties were.
You would assist in any capacity needed to put on these shows.
yes,
And you got paid by direct deposit, it's called. Is that what you, if you don't know that term,
yes,
you got a bank
yeah,
deposit.
transfer, yeah,
Okay. And to your knowledge, Jeffrey offered other people jobs too,
Objection.
from your area. To your
Not if
knowledge.
he says to your knowledge. That makes it not speculation. Overruled.
But if
Overruled.
Shut up, Miss Lord.
could you repeat it, Mr. Steele?
Yes, sir. To your knowledge, Jeffrey would give other job opportunities to other people too, right?
Yes,
So instead of giving money, you knew Jeffrey had money by 2014, right?
yes,
He was flying on planes, right?
yes,
He had cars, right?
yes,
He had places to live.
yes,
He had multiple places to live.
yes,
He had jewelry.
objection, relevance.
I mean, I think you made your point, so just move on to the next question.
But instead of giving just cash to people, he gave people opportunity to earn that money, right?
yes.
Now, do you have any evidence to tell this jury that Jeffrey ever
You must want.
told you or anyone else
If you know, you
to harm another person?
No,
To your knowledge, and I am not including drug use, and I am not including gambling, but to your knowledge, did Jeffrey ever encourage?
Apparently we need to take a restroom break, so let's break for a few minutes.
Yeah, the black dude.
We were not. Use the restroom. We just took a fairly long recess
Oh, she mad.
an hour ago. I'm going to remind y'all to please, whether you have to right then or not, use the restroom during recesses so that we don't then have to take another bathroom break less than an hour later. Okay, I'm going to just start making y'all hold it if you can't do that, because we take plenty of breaks without interrupting the middle of somebody's testimony. Okay, so keep that in mind for the future, please. Go ahead and go if you need to.
She talking to the lawyers. Couldn't have been the jury. Damn, judge was hot. I'm skipping, y'all. I'm skipping. Jeez. She was on one. Damn. They did take a pretty lengthy bathroom break, huh? Okay, let me stop skipping forward and just slide it for you.
Undo that. What do you, just again?
That one will have a class.
Enough of it around. I can't. Yeah. Embarrassment, a broken toe, who knows what else. All right, you may take the IT crown away from Miss Percival since she's not here this week. We can worry about that later. All right, we now have the ability to see on a screen that is not covered by some strange IT notification.
Sean John Wall wiping his nose.
Did you note the two basketball players?
Anthony Davis wiped his nose.
Mr. Sledge, did you note the two basketball players in that screenshot?
Yes.
And do you know them to be professional players?
Yes.
And were they doing something similar to what you were asked to show the jurors?
Yes.
I'd like to show you Mr. Williams' number 47. Do you know who that person is?
Broadway.
Can you tell the jurors, please, into the microphone?
Broadway.
And who is Mr. Wade?
He's a rapper. I am the type.
And that's W-A-V-E.
He had a basketball game.
And at the beginning, did you notice that young lady behind Mr. Wade?
No.
Okay. Look at the young lady right behind her, right there.
Oh, yes.
Wipe the nose.
And is that similar to what you showed the jurors?
Yes.
And then 49, Mr. Williams, 49. Do you remember discussing with the jurors that you've seen Nickelodeon slime? Do you remember that?
Yes.
Not the Knicks line.
This is going to be Jeffrey Williams, number 49.
The Nickelodeon.
And do you recognize that person as a professional football player?
Yes.
You know who that person is?
I don't forget the name, but
Debo Samuels.
And was it similar to the wiping of the nose that you were asked a lot of questions about or some questions about earlier?
yes.
Did you hear him say slime?
Yes.
Tell the jurors, why is slime significant to YSL?
I don't know.
Is it evil?
No.
Okay. And the wiping of the nose, is that evil?
No.
I'd like to talk with you about a posting that you were shown, and I forget the state's exhibit number. Give me 1 second. Remember the exhibit that you all played for Mr. Sledge saying, the number.
Did you need to say?
No, I think you're. Your Honor, it's already in evidence. Can I discuss with Mr. Sledge number 435?
Sure.
And that's State's Exhibit 9.
Yes. 435Y, right?
Yes.
Yes.
That's what I'm being told. Could you? Thank you. Sorry, I apologize. Do you remember this, Mr. Sledge, being played this? We're going to play. I'm going to ask the court to allow it to be played one more time by Mr. Knight, and then I'd like to ask you some questions, okay?
Yes. Marina. Stiff.
Lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
Now, Mr. Sledge,
Strong statements.
you told the district attorney when questioning that this is not a new statement. Do you remember something like that?
Yes.
And had you heard this before from growing up? From where?
Melissa.
Growing up, just I have heard it before.
Okay. Have you seen it and listened to it or read it on the internet?
I think I have seen it on the internet.
And you related this and you made this statement for, which is now memorialized as State's Exhibit 435Y. Do you remember what was going on at that moment?
No.
Okay. I'd like to show you what's already in evidence. And it's the State's Exhibit number. Do you have Jeffrey Williams? Thank you. What number is that? I'd like to show you 447Y. Your Honor, it's already in evidence.
All right.
May we publish it?
You may.
Thank you.
So nigga, a lot of they women, a lot of they kids, a lot of they brothers and sisters, they didn't get ready in the courtroom and tell God is true. Fuck nigga, don't get it. Y'all nigga get fucking killed, bro. You go. From me and YSL.
Were you able to hear that, Mr. Sledge?
Yes.
And was that, you were asked if that was your voice by the district attorney on direct examination. Do you remember that?
Yes.
And your response was something effective, it sounds like you.
Yes.
Do you remember the date that was made?
No, I don't remember the date.
I'd like to ask you if you remember the other persons who are speaking in that video, okay?
Yes.
And was it Jeffrey Williams speaking?
Yes.
All right. And was he the one seen on the video?
Yes.
And was it Martinez Arnold?
Yes, that's what it sounded like.
All right. And was the other person Mr. McMillan?
Yes, that's
Mr. McMillan.
yes.
All right. Now, I'd like to ask you if you can hear and listen to the very beginning of State's Exhibit number 437Y. Yes, excuse me, 447Y. I'd like to ask you if you can hear at the very beginning, does it say, I'm gonna swear to God, it's the truth. I'm gonna tell a lie on God. I want you to listen, okay? If it says it.
Okay.
So nigga, a lot of they women, a lot of they kids, a lot of they brothers and sisters.
Did you hear the beginning of that?
Yes.
Okay. And if you want headphones, the judge may allow that. Not the Judge Whitaker may allow that, but we able to hear The person speaking? Yes, that beginning part. And did they say, I'm gonna swear to God, it's the truth, I'm gonna tell a lie on God? Yes. Who said that?
Hang on, never mind. Yes, no.
Who said that?
I think that was, it sounded like my voice, but yes.
So at the beginning of this video, audio, is it fair to say that you're talking about going to swear to God to tell the truth and then tell a lie on God?
Yes.
Was this video something about people who lie,
Yes.
even though they're under oath?
They don't have to be on the oath to tell a lie.
Now, the next part that I asked Miss Knight, the Honorable Miss Knight, to play should be Jeffrey speaking, and it's similar to what you said in the video we just saw. Okay, does Jeffrey say, and listen to this, okay? So, and I'm just saying, and lie to their mama, lie to their kids, lie to their brothers and sisters, and get right in the courtroom to tell the God's honest truth. If you can just listen to that and tell me if that's what you hear Jeffrey say, okay?
Yes.
One more time. You can stop it, I mean, it's so short. Or can you stop it when that part ends? Thank you. So is it for my cue? Okay.
So nigga, a lot of their mama, a lot of their kids, a lot of their brothers and sisters, they didn't get ready in the courtroom and tell the God honest truth. Fuck, nigga.
Was that Jeffrey speaking?
Yes.
And is that similar to what you said on the other exhibit, which is escaping me, the exhibit number 435Y, state's exhibit? Is that similar?
Yes.
And are those words that you said are similar words that you've heard before?
Yes.
Did you hear those words before Jeffrey said those words?
Yes.
And then on the next part of it, I'm not going to say it, but it's FN. Ain't going back and forth with you, bro. And then Jeffrey saying, or then another person saying, tell nothing but the truth, so help you God. If you can listen to that, okay?
Yes.
And tell the judge who's saying that.
Yes.
Fucking kill, bro. Go. You snitching bitches? It's true. Fuck.
Thank you.
The God is true. Fuck, nigga. Fucking kill, bro. Go. You snitching bitches? From me and YSL.
Okay. Did you hear that? Tell nothing but the truth, so help you God.
Yes.
Is it accurate to say that in the criminal justice system, from your upbringing, your observation, people come in and lie under oath?
Objection, Your Honor. That's called for speculation about other.
He says from your observation. Of course, I don't know how he can know that.
You know it from personal experience.
It's speculation until there is a foundation established for his ability to answer that. A basis for knowledge, speculation about other people lying.
You can try to lay a foundation.
When you said this, and when you were part of this, and when I say this, I'm talking about states 447Y, what's up there right now?
Yes.
Tell the jurors what you were talking about.
Talking about people lying.
Okay. Now, I want to show you, I may have one moment?
You may.
Show it to the prosecutor. Yeah, can Mr. Kokomo show the prosecutor? This will be Mr. Williams. Thank you. Exhibit number 255. Sorry.
So Your Honor, I'm looking at 62 pages. Are we talking about 62 pages? That's what this is.
I'll shorten it, but I just did the dates from the,
That's the same 255 that we looked at before.
no.
No, it's a different,
Yeah, we stopped in July 2015.
okay, and,
Starts, I think, December or November 2012.
okay, and you were just gonna pick a couple of
Yes,
pages.
I'm not gonna go through 60.
Can we, is it possible to have them just specify which two so I can look at those? Or do I need to look at 62?
I'm gonna show it to
Yes.
Mr. Sledge first, obviously. And then we can do this.
Do you know which ones you're gonna use?
No, because Mr. Sledge has to identify.
Okay. I mean, you know generally what,
Yeah. I'll use the one from November 2012, I believe, and I'll look at it, but it'll be 2 or 3. That'll be it.
I mean, this is the same thing we looked at over lunch.
It appears to be, all 62 pages.
Yeah, no, I know.
Well, it's not accurate. It took out after July 15th.
Okay,
That's
well,
what, but I didn't want to cut it short for the Mr. Sledge to look at, but then I was going to just, once he identifies a few, I was gonna stop.
so, okay, so can you come up here for a minute?
Damn it. They quiet, my bad. I ran off. I was parenting. They didn't get quiet. It's good.
Mr. Sledge? Yes. We are going to trim down some of those items for you. Yes. For me. And we're going to get back to that, okay? Yes. I will not promise you I'll come back to it. Yes. If the state can show, again, Mr. Williams' number and the numbers of 4471. And if you can just look at it with me for a moment, if you don't mind. Now, do you see at the bottom, any way to clear the, thank you. You see at the bottom, it says repost, what is that? Yes. And then it says tagging at Thugger1, you see that? Yes. Do you know what a repost is? Someone else posted it, and it was posted to somebody else posted. So for an example, if I posted something a week ago, and you liked it, and you want to post it, what would happen? I hit the repost, and it'll let me repost it on another day. So the state was saying that this was done and shown and reposted on January 26th, 2015. You remember that?
Hang on just a second.
object as to the characterization of the question, the testimony.
Yes, I mean, the state would have asked a question and established that through a witness.
It's in the indictment as well. And if you're not familiar, do you remember this being in the
Okay, well,
indictment?
that's just an assertion.
Exactly. So I want to show you, you ready? What number is it? Actually, can you show it to the prosecution first? What number is this going to be? 256. It's going to be Jeffrey Williams, number 256. So.
Is this something new that's not in what you've sent before?
True.
Okay,
I'm trimming down.
that's fine. Oh, I got you. Okay.
Oh my goodness.
Can Mr. Kokomo approach Mr. Sledge?
Yes.
Mr. Sledge, is that okay? Yes. Just take a look at this, telling me whether you can recognize it and you can hear it as well, just to make sure. But don't make it loud enough for the jurors yet.
So, Your Honor,
Mm-hmm.
prior to that being displayed, what we have not heard is the sound in that video, because this is the first time we've seen it. So we'd ask that before anything be done with it, the state be allowed an opportunity to hear what is being said in that particular video, which is a little different.
I don't know if it's different or not.
It is, I'm looking at it, it's not the same exact thing that we just put up.
Okay. Then I guess this will be where we break for the evening.
No, it's 11 seconds. I mean, if that matters.
Well, or we can see if Ms. Love can hear it without. Do you want to step out into the hall? That would be easier than excusing all of them to the.
Yes.
All right, she'll be right back. We'll sit for just a second and I'll let y'all go soon.
Go with your computer.
And Mr. Steele, estimate for me how long you think the rest of your cross is going to
30 minutes.
Do y'all want to stay for, who else has, if anybody has going to have cross for this witness? Anybody? Okay. Okay. Do you want to just, well, do you want to stay 30 more minutes? So that we'll have a redirect on Monday. But yes, I have some thumbs up for 30 minutes. Lots of nods for, okay.
The only issue I just want to make the court on the 62
Yeah.
item, that's the only thing I have to go over, which is going to take a little more time. So I just want you to, I won't finish.
All right. We'll get 30 more minutes and then we'll see where we are. Okay. All right. Then I guess he's already seen it.
Yes.
So go ahead and ask whatever you need to ask.
Mr. Sledge, have you seen what is now marked as Mr. Williams number 256? Have you seen that before? Yes. And is it accurate? And does it depict the way it was when it was first filmed or filmed and audioed? Yes.
And I two things. I object on the basis of the vagueness of the question. Have you seen it before? I don't know if that means before he was shown by the.
Well, can you clarify that?
Were you present when that was made? Yes, I was present. Is your voice on there? Yes, my voice is on there. Is it the same as, and I always forget, 447? 447Y that was shown to the jury at the repost? Yes, my voice on there. Okay.
Okay. So on 256, JW 256 is that what you were just asking the questions about? He was present for? Okay. All right.
With that, I have no objections. He said he was there.
All right. Go ahead.
Your Honor, with the court's permission, Mr. Kokomo will publish Mr. Williams number 256.
All right.
A lot of their kids, a lot of their brothers and sisters, they didn't get ready in the courtroom and tell God the truth. Fuck, nigga. Don't get it. Y'all niggas get fucking killed, bro. Go. From me and YSL. So nigga, a lot of their mama, a lot of their kids, a lot of their brothers and sisters, they didn't get ready in the courtroom and tell God the truth. Fuck, nigga. Don't get it. Y'all niggas get fucking killed, bro. Go. From me and YSL.
Mr. Sledge, did you hear your voice? Yes. Voice of Mr. Jeffrey Williams and the face of Mr. Jeffrey Williams? Yes. Did you hear the voice of Mr. McMillan?
Yes.
Did you hear the voice of Mr. Martinez, also known as Duke?
Yes.
Is it the same exact video that was played earlier as the repost?
Yes.
And on Jeffrey Williams number 256, I'd like you to tell the jurors, it's small writing, if you could read it to them, what date at the bottom right was this made?
January 4th, 2015.
And on January 4th, 2015, what was Jeffrey Williams' relationship like with Donovan Thomas from your personal observation?
Objection made.
Overruled.
They had a great relationship.
And does this video on January 4th, 2015 have anything to do, from your own personal knowledge from being in it, about Donovan Thomas or threatening some witness or anything?
No.
Objection. One is compound, so I don't know which part of that he's asking about. And then the second part, he is speaking to the intent of Defendant Williams when he says, does it have anything to do with threatening something?
Okay, well, it's his personal knowledge, and while Mr. Steele does ask long questions sometimes, he has a lot of clauses in there. I don't believe it was a compound question, it just had a lot of descriptive clauses. So overruled.
So the indictment, and if you don't remember, we'll show it to you. No one's trying to keep anything from you. Says that this was done 16 days after the killing of Mr. Williams, that it was reposted. But this was made 6 days before, God forbid, the killing of Mr. Thomas, right?
Yes.
Now, if you can look at the very top right-hand side, you see where it says watch your post? You see that at the top?
Yes.
And then underneath it, it says watch your post, and then it says best said at MPA Duke, DUKE 1, the number 1, said it first, 3 exclamation points. You see that?
Yes.
Who, to your knowledge, is MPA Duke 1?
Mr. Arnold.
Martinez Arnold?
Yes.
And
Withdraw.
then it says video by at Thugger1 pound YouTube pound Young Thug pound Thugger1 pound Urban Post. You see all that?
Yes.
Okay. And when it said best said at MPA Duke 1 said it first, that's Mr. Arnold?
Yes.
Saying it first.
Objection as to that.
Yeah, sustained as to that.
All right. Now, I want to ask you other questions if I can. Before January 4th, 2015, were you familiar with this type of statement?
Yes.
Now, if a witness, when it says at the end, the prosecutor said, y'all should be killed. Let me make sure I got it. Hold on a second. Y'all should be killed, and that's from me and YSL. Remember that?
Yes.
I didn't quote it perfectly. Something to that effect?
Yes.
Okay. From being there and being a participant in this video, which is 256, Jeffrey Williams 256, what do you believe should happen to a witness who lies about someone's job?
Objection.
Sustained.
Okay. All right. Let me ask you this. You were released from prison from the drive-by shooting. Remember, the jurors heard a lot about that, April of 2015?
Yes.
And is it fair to say you were released in the year 2019?
Yes.
And when you were released from prison, you needed a job, didn't you?
Yes.
Okay. You were financially depleted. You didn't have much money?
No.
All right. And is it fair to say that Jeffrey at that time was even more popular than he was in 2015?
Yes.
And did Jeffrey offer you a job?
Yes.
Was it conditional? Did you have to promise something?
No.
How about no more crime?
No.
You withdrawing that objection?
Did Jeffrey tell you you can't commit
Objection.
crimes?
That right there is hearsay.
Sustained.
Come on, Judge.
When you were on tour with Jeffrey, and from your personal observations, I'm not asking you what other people said or anything, did you ever observe people who would steal from other people, from stores or anything like that, and Jeffrey would find out about it and repay those people?
Objection, Your Honor. Relevance.
Sustained.
Well, I think it's relevant. You're the leader of a supposed organization.
I object on the basis of whatever the speaker's objection is about to be.
I think it's relevant, more than relevant,
Your Honor,
to the conduct after this trial.
his character, he's trying
That's
to.
not-
character
Sustained.
evidence.
All right.
Damn it, Judge.
Do you remember seeing in the days before Donovan Thomas was killed? Do you ever remember seeing, personally seeing Mr. Kenneth Copeland with an Infinity vehicle?
No.
When you drove Mr. Copeland to the police department on the early morning hours of January 11, 2015, is that true?
Yes.
And your significant other, the mother of your child, was with you, as well as your youngest child at that time, right?
It was my youngest child, my oldest son.
Apologize. Okay. And Mr. Copeland didn't have a car there, right? That's why you drove him? Am I correct?
He didn't have a car there.
Do you remember at all whether Mr. Copeland asked you to pick him up and drive him to Jeffrey Williams' house with you for safety?
I don't remember that.
Okay. Do you know how, as you sit here today, do you remember how Mr. Copeland, if you know, got to Jeffrey Williams' home on January 10, 2015?
I don't know.
All right. Has Jeffrey ever paid for your lawyer fees?
No.
Has he ever paid for your bond?
No.
Your Honor, I believe except for the, I have to break down the 62, which I probably can't do in a short period of time. I don't have any other questions.
Okay, well, so is your plan to?
I'll try to do it, with the court's permission, I'll try to do it with Mr. Wright and figure out if there's a quick way to get it through. I'm not gonna speak with Mr. Slade. I don't mean any disrespect, but I'll go through it.
Your Honor, with the court permit outside of the jury's presence, for the question to be placed upon the witness so that the court can hear.
Sure, yeah, that may be a better way to do it. Okay, all right, so we are going to break for the day and for the weekend, and I am going to remind all of you to not talk about the case with anybody. Don't let anybody talk about it with you. You are only supposed to decide this case based on the evidence admitted inside this courtroom, so don't conduct any research on your own. Don't try to find out anything on the internet or from old school sources or from other people, from social media. Don't do research about the law. Do not read, watch, listen to any accounts of this trial online, in print, television, otherwise, radio, social media, anything like that. And leave your notes in the jury room, and we will see you on Monday at 9. Y'all have a great weekend. You stay here with us for a minute.
Oh, okay.
We're going to ask you some more questions.
Oh, okay. You better say something. I'm trying to go. I ain't charged it. Someone be charged.
Excellent.
Okay, Mr. Coco.
Yes.
I'm going to ask the court, there's no jury here, but we're still in trial, okay?
Yes.
I'm going to ask, with the court's permission, to approach you and show you. And I'm just going to pick out a few. And just tell me whether you have ever seen these postings online before this week, okay? Is that okay?
Yes.
I'm going to target a couple, but it's going to take me a moment, but I think I can target a few.
And Your Honor, if Mr. Steele would simply apprise the court and counsel for the state which ones he's targeting and approaching him with, so we could at least write it down.
I'm going to do that. And Mr. Kokomo, and I push this for a minute, Your Honor?
Yes.
Mr. Sledge, can we come to you?
Yes.
And just be real clear of exactly what you're asking him, not post like this.
We're going to, Mr. Kokomo is going to show you. Can you pull up the one that's, it says, it's, December. If you have not seen it, I'm sorry, okay. If you have not seen this before, don't just tell us I haven't read it, I haven't seen it, okay?
Yeah.
If you have seen it and read it, just tell us I have seen it and read it.
Your Honor, could Mr. Steele place just on the record the one he just identified for Mr. Kokomo, but I could barely hear.
Or just spin around and show Miss Love.
If I could see it.
This is a DMAC.
Just spin around and show Miss Love. It'll be easier than trying to set people's names or tags or whatever are kind of hard to read out.
We'll read it, okay? Okay. And it is, I'm just orienting myself. This is Mr. Williams exhibit number 255A, and it's down here. It says DMAC got me to banging at DMAC to banging. You see the date?
Yeah, that's
December 27th, 2014.
Yeah, too bad.
And this is me. I'm not reading verbatim, okay? And ANY to their mama, brother, sister, and kids, but get to the courtroom and tell the God's honest truth, question mark, question mark, question mark. I don't get it. Or ION, get it, hyphen, have young thug. You see that?
Yes.
If you can remember, you can, it's fine. And just tell us, have you seen that before this week?
Have I seen it
That particular post.
This week? No.
anytime?
This week.
I can't remember exactly what day I seen it, but I don't seen this before.
That's a good,
Yes.
Have you seen it?
Judge, is he talking about that?
When you
It's
see
the post.
DMAC got to me too banging on December 27th, that post, you saw
Yes,
that
I
post.
saw this post
All
before.
Have you seen it before this week, just to make sure?
Yes, yes.
We're gonna have to mark that. Can you pull up the one that says, don't you know, it's if you don't know it, my notes. That's the next one.
Mr. Kokomo. No, he Nigerian. True. Take him forever to do that. He still got too much left. That's it, y'all. It's just about 20 minutes left, but they ain't doing nothing. This outside the listening ears of the jury. Fuck them last few minutes of testimony. We caught up. I'm reckoning we'll do live coverage tomorrow. Well, no, we got a doctor's appointment tomorrow. I don't know. We'll be back tomorrow with this. I don't know what I'm gonna do tonight if I do anything. I gotta find something. I was hollering at Truth to see if she was going live, but she ain't answering the phone. She's still cooking breakfast, I guess. But until the next episode, we out.
No, oh, no, oh, no, oh. Niggas don't talk no more. Niggas don't walk no more. Niggas don't want no smoke. They saying my name, look in the mirror. Shout it 3 times and I might appear. These niggas is lame, die for the fame. Rerouted my ship like a buccaneer. I play my position, trust my intuition. Move when it's time like the minute hand. I'm snoozing the clock, I be tired, man. I run up the check like a Nike fan. I get it to go, I Uber my eats. Bread on the move, the debit truck. Say what you want, I'm making my plays. I'm deaf to the drama, I don't give a fuck. I blocked out the chatter, my pockets got fatter. I'm serving them up like a tennis ball. I'm close to the net, I can't hear it all. I'm killing them easily, fentanyl. I carry my cannon cause niggas be plotting. Watching and planning, they wildin' out. You thinking it's sweet, get tricked off the streets. And the pussy they be only dialing out. The harder the head, the softer the air. Grandmama told you, go take a seat. I'm pinching my pennies, I wanted a Bentley. You rapping and broke, boy talking cheap. Speaking in riddles, your vocab is little. Passing out threats like a python. What you saying is cap, tag on your head. Shooting your code with a price gun. They claiming they grown, but ain't got their own. A clone with a phone, pocket down. In all of the movies, the villain gon' die. Him all alone, Joker smile. No, oh, no, oh, no, oh. Niggas don't talk no more. Niggas don't walk no more. Niggas don't joke no more. No, oh, no, oh, oh, no. Niggas don't talk no more. Niggas don't walk no more. Niggas don't want no smoke. No, oh, no, oh, no, oh. Niggas don't talk no more. Niggas don't walk no more. Niggas don't joke no more. No, oh, no, oh, no, oh. Niggas don't talk no more. Niggas don't walk no more. Niggas don't want no smoke.
His mama died, he apologized. He's not who he's televised. I tell a lie, just a lie, a lie. His pants on fire, no lie, a lie. Fuck friends, fuck family. Fuck niggas, a lot of enemies. He go back and forth with the best of them. Straight drop, he tested them. All my my niggas, they gang bang. If you don't see me with them, we insane gang. Number one rule, no hating, man. Niggas mad about donations, man. No. JJ ain't pull up yet. Nike on my feet, he ain't got no check. Pussy ass niggas still living
no smoke. Don't want no more. Certified student, grip the Mac like a pro. Posted up, pocket full of down to the stove. Mr. Double Up, got nothing for the low. Close out, sell, everything gotta go. Yes, sir, everything gotta go. I used to be cool with a nigga from the south, buddy. I was running his mouth packing just like a hoe. Now what, bitch? Put it all on the floor. Better watch your mouth, cause you know you a hoe. Dressing all black, 3 killers at the door. Make a go, stop the mob, bitch. I really want to smoke. Now what, nigga? You a pussy, you a joke. Setting 4 shots like a nigga with a boat. Dressing all black, 3 killers at the door. Make a go, stop the mob, bitch. I really want to smoke. Stick game.
No, nigga don't talk no more. Niggas don't walk no more. Niggas don't joke no more. No, niggas don't talk no more. Niggas don't walk no more. Niggas don't want no smoke. No, niggas don't talk no more. Niggas don't walk no more. Niggas don't joke no more. No, niggas don't talk no more. Niggas don't walk no more. Niggas don't want no smoke.